lost to the state exchequer.
How?
Malos, what happens, Malos? For example, I give 100 rupees, Malos. No GST, no TDS is deducted. For example, 3.5 crores was recovered in 3 races.
Now, when they will hear a trend length, when the event is to take place?
Tomorrow, my lord. Tomorrow, my lord. 12 races already. 1:30 in the afternoon. First race is at 1:30 in the afternoon tomorrow. Horses have come, trainers have come, entry fee is paid.
Let them run, Malos. No, let them not do any betting, Malos. The question is this.
Yes, my lord.
That's the whole problem.
So
let it be 2/3.
Please, Malos.
2/3.
Please, 2:30.
Not so far as racing, without the bookmakers, we have no difficulty. In fact, learned judge has noted our submission. So without bookmakers, it can run, my lord.
Let the race be there, but without betting.
Malos,
Yes, yes, my lord. Yeah, without bookmakers, man.
Without no. They what here, Malos, they are not actually concerned. This case is funded by the bookmakers who are betting on. They are actually the learned single judge only has granted interim order saying that if horse racing is not permitted, it will cause disease to the horses. It will cause disease to the horses. Therefore, I am permitting a horse racing. I'll find out, Malos. That is the finding given for irreparable injuries.
If the race has to run,
now, millards.
Lord, if race has to be run, my lord, I have no difficulty, my lord. There are two types of betting that takes place, my lord. One is by the bookmakers.
2:30 will argue, my lord.
Their main case is bookmakers are doing illegal things.
No, that is
we
not
will
my
not
case.
give license to bookmakers.
That is not my case, my lord. Let him not say what is my case.
Submit, my lords. Just now they have served the documents. It is too bulky. I'll require much. At least Monday it could be here.
That is what I asked before. Single judge, kindly hear the matter. I want time.
That's 18:30, my lords. The racing activity has started. Now, till today, please, my lord, there has been no fault. Some two people, please, my lord, they raid the premises of two people. Now, my lords, kindly appreciate the trainers, my lords. 2,000 people.
Yes, it can be postponed. Nothing is going to happen. It can be postponed. Nothing is going to happen, my lords.
2:30, let us have it.
I will explain, Lord, how the race is. Lord, this is all India impact it is going to have. A race having been held in Bangalore, betting takes place in every center in India. Entries.
Bulky documents are there.
Nothing. Thank you,
From
sir.
all over the country, Lords, I appear for the Horse Owners Association. The summer season starts, my lords. It's only here which races go on. 800 horses are here. My lords, these are thoroughbred horses, not some my lords, and we have to maintain them. And my lords, we lost out from May. We have lost out the schedule. My lords, and there is no allegation against the race owners, horse owners. It's only against the bookies. BTC has said, the club has said, no bookies will be allowed. It is only through this club system that any betting will take. 2:30, your lordship have.
Bulky documents are
taken
up on Monday. My only sir. 2,000.
Yes, that has to be considered. Learned judge is considered.
One of the concerns which we placed. Let's have it at 2:30. Please.
Serial number 20. Serial number 20, my lord. My senior counsel has undergone heart surgery and is not able to appear. Kindly adjourn this matter for 2 weeks. Serial number 20. I appeal for the petition.
And for the respondent.
With your lordship, kindly.
2 weeks. 2 weeks. I appear for the petitioner. K.N. Srinivas.
With your lordship, kindly. With your lordship, kindly. 59, serial number 59.
in serial number 1, my lord, I appear for the petitioner. The petitioner in this case, my lord, are traders of certified automotive parts. The accused, my lord, is the Department of Road Transport and Safety. And my lord, the accused have not complied with the order passed by this honorable court, which is at page number 10. And my lord, the writ petition at page number 10, my lord, was instituted by the petitioner seeking strict implementation of Rule 104 of the Motor Vehicles Rules. And my lord, 104 states that retro-reflective tapes of a certain quality and certified retro-reflective tapes will have to be affixed on motor vehicles. And despite of there being state circulars to this effect, my lord, the Karnataka government was not implementing it. Therefore, we filed the writ petition for strict implementation. The honorable court, my lord, has passed an order recording the circular that was passed by the Karnataka government. If I may read, my lord, in page number 12, this last 2 paragraphs. Para 3, learned senior counsel for the petitioner's counsel submits that the petitioner has filed a memo along with the circular issued by the respondent number 2 for the strict implementation of Rule 104 of the rules. Therefore, it is expedient to dispose of the petition
The vehicles, though fitted with the reflective tapes of the inferior quality, reflective tapes, though fitted with the reflective tapes, they were of inferior quality, and yet the fitness certificates are used to be granted by the authorities. Full stop. The petition was disposed of by the court requiring respondent number 1 and 2 to implement the circular dated 22/2/23 received by the authorities in regard to the subject matter, and to take appropriate action in the event if there is violation of 104 Rule 104 of the rules. Now, what is contempt here?
Now, my lord, despite the order, my lord, there's been no implementation at all. In fact, I filed for RTI.
So the grievance, the
RTI
opposite directions are brought under contempt jurisdiction with a grievance that the circular is not implemented. Full stop. It is on 2 counts, that paragraph. The court is not inclined to entertain the contempt jurisdiction. Firstly, there is no detail about the violation of, there is no detail about an instance having been occurred which violated Rule 104 of rules. Secondly, in any case, the directions are not coupled with any time limit for implementation. Full stop. In the circumstances, it is not possible to conclude that any of the respondents have committed contempt of the court when there is no time limit is prescribed in the order to implement the circular. Full stop. At the same time, the anxiety of the court is that the direction should not go uncomplied with. Therefore, it is provided that if any event is noticed, any incident is not any incident is noticed by the authorities, which amounts to violation of Rule 104 of the rules, the necessary action shall be taken within 1 week by the authorities. Full stop. With such observations, the contempt petition is disposed.
Number 2, to NG parte.
The complainant
Notice returnable on 24th July.
Number 3, to Shrikant MP.
For complaint, Annexure B, Lords, is the order of the learned single judge, Lords, page number 24. Page number 27, Lords, paragraph number 8, Lords, is the relevant directions.
What is this? No contempt.
Please, my lord.
You are permitted to appoint
Permitted to appoint, my lord, what
Lecturers.
happens, my lord, insofar as
in the college at the earliest within 2 months.
respondent authorities should permit us.
So you are permitted, you appoint.
No, that is not done by the authorities now, in spite of the directions issued by the zone
Who are
code.
you?
Lords, I am the management, lords of the
So
institution.
you are not permitted.
I am not permitted in spite of, lords, representations being made. Without permission, lords, I cannot appoint. There's a difficulty I am facing.
Permission is not granted.
Not granted, lords, in spite of the order of the learned single
Notice
judge.
returnable on 22nd July.
Please.
Number 4, the Sagar V. Shastri.
Please, your lordship. Not the,
What about the direction number 3?
not the, they have
Delay
Page
in compliance
46,
would
page 46, direction number 1 applies to us, my lord.
Notice returnable. 22nd July.
Number 5, Mr. Mohammad Tahir.
Notice returnable on
Please.
23rd July.
Number 6,
Pay for the complaint.
Notice returnable on 24th July.
number 7, Hemalata Maishi. Number 7, Hemalata Maishi.
So 22nd July, simple. Or say 10th July, simple. No keep, no pass over.
Number 8, Mr. Srinivas Murthy SR. Mr. Srinivas Murthy SR.
10th July.
Number 10, number 9, Adinaranappa.
Direction to
Notice
change the
returnable on
kata.
24th June, 11/9.
Number 10, Mr. Mahesh Harkalgood.
Remember 10, yes.
10.
The order of the learned single judge, my lord, at page number 116. My lord, matter pertain, I filed a writ petition, my lord, because there was illegal construction in my neighbor's property. I had given representations to the BBMP which had not acted on it. Consequently, I filed a writ petition for a mandamus. Thereafter, my lord, on page number 116, my lord finds the order where the BBMP says that it will implement the order with the help of the jurisdictional police. Thereafter, my lord, the construction continues to go on and they have not done anything.
Go
to-
before learning single judge.
My lord, this is the order which I obtained, my lord, after going back to the learned single judge. If my lord looks at the initial order, my lord, that was passed, which is, my lord, at page number 71. This was the order which was originally passed by the learned single judge.
71.
71, my lord, was the order passed by the learned single judge. Where, my lord, my petition was disposed of. And if my lord would see page number 74, paragraph number 8 and 9, taking note of the order passed under section 248(3), pending appeal before the chief commissioner at the instance of the private respondents, petition is disposed of, directing the respondent BBMP to take appropriate action if the order under 248(3) attains finality. All conditions of both parties are kept open. Insofar as the assertion of petitioner that construction is still ongoing, it is up to the BBMP to take note of it appropriately. Learned counsel appearing for the respondent BBMP makes a plea that the appeal pending would be taken up at the earliest.
So here there is nothing about construction.
Right. So what happens after this, my lord, is that I would invite my lord's attention to the order that was passed in the KAT, because they said there's an appeal pending in the KAT. And if my lord looks at the typed copy, my lord, at page number 80 and the relevant portion at 81, the KAT, my lord, ordered that there be a status quo on the construction, which too, my lord, was not complied with, because of which, my lord, I went back to the learned single judge with an application asking for a modification or a clarification of the order. At that instance, my lord, the learned single judge passed this order whereby the BBMP gave an undertaking that they will take the support of the jurisdictional police.
Nothing, notice returnable on 26th July.
Grateful.
So PL matter, seal number 11, Mr. Ganpati Bhatt.
I'm appearing for petitioner.
Now, are you able to demonstrate that this land is essentially a water body?
Yes, definitely that I have produced enough documents.
Let us see.
Kindly see the annexure A. Annexure A in page number 69.
translated copy is at, my lord, 70.
What make you to?
Please,
wake
my
up?
lord.
What make you to wake up?
My lord, that we, since, my lord, this is the property which is water body, and now, my lord, that we, not first time that we are coming up.
But Mr. Much water has flown since 19.
I'll establish that, my lord. Recently, the deputy commissioner has cancelled plan. It is not constructed, vacant land. And when they have approached, my lord, for construction sanction plan, immediately that we have approached, and from 2013 that all documents and, my lord, representations has been given. And now, my lord, the plan has been cancelled. This is absolutely, my lord, the deputy commissioner also come to conclusion that this land cannot be granted. And the corporation, municipal council has no right to execute sale deed without prior permission from the government. If your lots of permits, I'll establish each document, my lord, which shows this is the water body.
Then the auction was held after permission.
No, without permission, my lord, corporation, since, my lord, it's granted. Deputy commissioner has passed order, grant in favor of municipal council, grant order. And subsequent to that, my lord, municipal council, without prior permission from the government, executed sale deed in respect of that property for 5,000. Under section 71 of the Karnataka Land Revenue Act, the land should be, my lord, the government permission has to be obtained, and, my lord, thereafterwards sale has to be, market value of the property has to be determined. Then, my lord, they have to sell. That has not been done. Kindly see. I'll draw your lots of attention.
Who are you? Who are you?
I am the villager, and I am affected because, my lord, this is a public property, and this is clearly all the documents.
Claims that the petitioner claims that all lands, land expenses, also the petitioner claims that the land in question is open land and that it is a public body, it is a water body. So recorded in the revenue records, so reflected in the revenue records. It was submitted that the events of sale and auctioning of the said land was without permission and were unlawful acts in view that the water body could not have been subjected to such transactions.
Ink page number 250.
Tenable on 25th of July.
258, my lord.
Learned additional
My lord, I
government
take notice for respondents 1 to 5.
1 to 5.
Respondent
just-
number 6, my lord, note.
Only because he has produced the document showing that this land is water body at one point of time.
Yes.
Then how you treated?
No, that I'll trace this thing.
Respondent 6 and 7 may be noticed, may be ordered.
So rest of the respondents will be solved.
Much of it.
Green bench matters, seal number 12, Mr. Radhakrishna Ulla.
For the petitioners, my lord. The petitioners of residents of the Timage village of Chitradurga district, my lord, aggrieved by the stone crushing activities of the respondent number 5 to 7, my lord. Earlier order of your
Notice returnable. I reply.
Last may kindly see the prayer. Prayer
Prayer.
1 says mandamus to stop the quarrying activities.
This is also PIL.
Yes, PIL.
PIL.
It is actually lease granted in favor of 5 to 7. The last may direct us to consider page number 96 representation given to submitted to the Deputy Director of Mines and Geology, Chitradurga.
no, annexure F is, my lord, the reports of the
He is the competent
by the
authority.
village authorities through Tahsildar to the third respondent.
Translation is at
No,
101.
yes, translation is at my lord, page 131. Your Lordship, kindly see that nothing has happened afterwards. It has been brought to the notice of the third respondent. Illegal activities are going on. The report says of the village authorities that they are violating encroaching the government land and all sorts of these, activities are.
So you are also carrying out the mining activity? He is also carrying?
No, they are the villages.
Villages.
They have complained against the quarrying activities. It is not crusher.
See the photographs.
Earlier order is an annex A, my lord, page 31. It is in respect, of course, some other person was carrying on illegal activities. After noticing that action was taken at page 33, your Lordship, kindly see operative portion of the order. The proceedings are dropped after taking note of the action taken by the government authorities then. Subsequently, my lord, now the respondent number 5 to 7 are indulging in the same activities, in the same village.
Will consider the Lord representation at 101 in a time-bound manner, so that grievances of the villagers will be addressed.
Further action is necessary in pursuance of annexure F, my lord, because they have submitted reports.
Notice returnable on. You file reply before the next date. 18th of July.
Notice has to go to 5 to 7.
1 to 4.
I-80.
Learned Government Advocate Mr. Mahendra accepts notice on behalf of 1 to 4. The rest of the respondents shall be served. Full stop. The reply from statement of objection shall be filed before next date.
Number 13, Ravindra Gajanam.
Now, if this appears to be serious, the way they have,
Please, I'll seek in.
subject to what you say.
Please.
Please, my lords. Absence of yesterday may kindly be condoned, my lords. I was unwell yesterday.
This was it was heard.
Yes, my lord.
Monday.
But I may kindly be permitted to add one more word, my lords.
On Monday you may.
Please, my lords.
Yes.
Writ appeal matters, seal number 14. Ajay Kumar M.
The appellant, the matter, the single judge has now quashed the modified layout plan which was prepared by the Mangalore Development Authority as per annexure R. What's the total?
We'll see notice returnable on.
Please.
24th of.
Wait.
Number 15. Mr. K.R. Ganesh Rao.
My lord, appellant joined the Canara Bank, respondent bank, as a part-time employee from 1/10/2003 for a consolidated wages of 600 rupees per week, 600 rupees per month. Working hours is 6 hours. But as per the settlement, less than 6 hours, page number. He is appointed for less than 6 hours, 1,050 rupees is the wages, my lord. But he has been paid 600 rupees for 6 hours. Part-time employee. page number 100, my lord, annexure D of the petition. So he is underpaid. His forced labor, my lord, Article 23 attracts.
Instruct them to have the list of events and index before this read petition. Don't circulate the matter unless it is very difficult to find out. Yes. Now you produce after page 55 the list of events and the index of the main petition. Otherwise, we will not take up any. No, that is not there, not common. The original which you had filed at the time of writ petition, the list of events and the index.
No, I have filed.
Prepared, but is not, you have not filed it.
Petition I have filed.
Where is that? So insert at appropriate place.
Copy of 56, page number 56, my lord. Copy of the.
Nahi hai, only petition starts. Regular petition starts. Where is the index and index of the
Index
petition?
and synopsis I have not.
Wahan, kahan hai? Where is that?
Nahi.
We have filed it at this place only.
Separately shall I file?
Not separately, to be inserted at the place where we indicated.
Okay, my lord. Some date may be.
Petitioner is appellant is permitted to file the index and the list of events to insert it at the appropriate place in the compilation, which were the index and list of events filed along with the original writ petition. Next, to be listed on 8th of July.
Number 16, Mr. J. Karshati.
That group has gone when? Nikant. 3rd July, notice written on 3rd July.
My lord, this is a little different, my lord.
No, here.
My lord, this writ appeal is a little different from the earlier matters which my lord is
Here,
referring to.
question of law is involved, my lord. Earlier, the division bench has held occasion to deal with the, my lord, section 5(3) of the act. Because the fourth respondent here, my lord, is a trespasser. Whether act applies or not is a question, man. So even the purchaser right is not protected under the act. But now, my lord, the trespasser is enjoying the property, saying that there is no contravention of the act. So 5(3) says, my lord, that has been, in fact, my lord, I have that point as urged by me before the learned single judge also, that has not been considered. Because earlier, my lord, division bench of this honorable court, when there is no instrument of transfer, then a person who is in possession, then what would be the consequences? Then the section 11 of the act, my lord, overrides all the laws. So I can't be driven to the civil court for eviction of those persons because I am protected under the act. So that is why, my lord, this honorable court, division bench of the considered that point, my lord, held that, my lord, that possession itself is in contravention of the act. That I have quoted in my appeal memo also, my lord. The only question here, my lord, whether 5(3) can be invoked in this case also is a question. That point has to be decided. That point has not been considered by the learned single judge. No, my lord, the purpose of the act itself is defeated. Because Trespasser is saved now. Even though purchaser for valuable consideration is not saved by the act. Learned single judgment observes the civil court has to, because there is a bar under the act, so far as granted land is concerned. So even if there is a decree, it can't be executed. That is the section say 11 is very clear. So I can't go there. Even if he goes, even if he gets a decree, that is not cannot be executed. So granted land has to be dealt with by the authorities only under the act. That is the question, my lord.
My lord, paragraph 11 is very clear of the order of the learned single judge.
Paragraph
11.
11.
Yes.
No, the point is here, my lord. Maybe, my lord, that has to be decided, my lord. The division bench judgment of this court is already has considered regarding legal fiction, my lord. When this kind of a situation arises, because there is no instrument of transfer, then person who is not a grant is in possession. Then whether he can defeat the very act. Then, my lord, subsection 3 of 5, section 5, my lord, comes into my benefit, my lord. Otherwise, my lord, I can't have any remedy. Because act is protected, protects me. It is not the case of the respondent, it is not granted land. Admittedly, it is granted land and he claims in another survey number, but he is in possession of the, that is the report of the Tahsildar, my lord, he is in possession. There is no dispute also. No question how he can be evicted. Whether I can invoke the act or civil code. But civil code, my lord, that is barred. Now purchaser is not saved, my lord. But trespasser is saved now. In view of this analogy, my lord.
Where is the order of the deputy commissioner?
That is in page 44. Annexure A.
Annexure A.
A, in page 40. So relevant page is in internal page 50, my lord. First para.
Page.
50, 50. Typed, translated copy.
Yes.
With regard to this case, report was obtained from the Special Tahsildar Baindur. As per the said report, it is found that survey number 206 for 8, measuring 34 acres of land situated in now in the village, was granted to the appellant Muttu so and so in the year so and so. In this regard, RTC also been changed in the name of the grantee.
Not
It is
relevant. What you are reading is not partial. Read the relevant part.
So there, my lord, it has been mentioned, my lord, he is in possession. So next pair, my lord, so far as eviction is concerned. PTCL Act applies when the land granted to the person belonging to the SC/ST is being illegally transferred. Under this situation, granted land is required to be restored to the grantee. The case before the Assistant Commissioner is not against the grant order made in the name of the first respondent so and so, measuring so and so. But the case is with regard to eviction of first respondent who has by mistake constructed his house in survey number so on, the land bearing 206 for 8, measuring 34 cents was granted to the appellant. There is no dispute about the grant. In this, for this grant, 60 times land revenue was imposed, but it was exempted from payment. That means the grant was free grant. Section 5(3) is very clear, my lord. We just read it. Because legal question is involved. That's why, my lord. Because learn
dismissed. There is nothing.
Obliged.
I will just read the section 5(3), my lord, because division bench also, my lord, considered that in that 5(3) statutory presumption. Because otherwise, my lord, the purpose of the act will be defeated.
Ultimately, it is question who is encroached it.
Please, my lord.
Ultimately, the boils down to the encroachment.
That is not in dispute, my lord.
What is not in dispute?
But Tahsildar report says he is in possession. So now, my lord, under the act, that also the authority can go into, because civil court is barred under section 11.
Read it. Read it.
Please. The resumption under section 5 is incorporated to the extent that any person other than, this is very important, any person other than the grantee or his legal representative who is in possession of the granted land, it shall be presumed until the contrary is proved that such person has acquired the land by transfer, which is null and void under the provisions of section subsection 1 of section 4 of the act.
Where you are reading?
5(3), my lord, subsection 3 of section 5.
For the purpose of this section, wherein granted.
Statutory presumption, my lord. Subsection 3 of section 5.
It is a matter of evidence.
Lord, that's not applicable, man.
Doesn't have a 4 will apply. Dismissed.
Obliged.
We'll deal with your argument.
Number 17, Mr. J. Prashant.
Yeah, for the appellant one. Lord, by government order dated 13/10/2010, my lord, additional pension of 20% of the basic, my lord, was given to the pensioner, my lord, as and when he attains the age of 80 to 85 years, my lord. Your lordship will get the government order at annexure E, my lord, at page 38. Page 39, my lord, the lordship got it, my lord. Page 39, the grant of additional quantum of pension is subject to fulfillment of the following conditions. Italic A. May I read it, my lord? As and when the pensioner attains the age of 80 years and above, he/she is entitled to the additional quantum of pension as indicated above. The additional pension, family pension, shall be admissible at such rates as is indicated above from the month the pensioner attains age of 80, 85, 90, and 95, my lord, and 100 years respectively. Now, my lord, the appellants, my lord, they had completed 79 years of age. Their contention was that, my lord, as and when they entered the age of 80, my lord, they were entitled for the 20% of the additional pension, my lord, since they had attained age of 80 years. Now, my lord, one of the judgments, my lord, before the Honorable Guwahati bench, my lord, it held that, my lord, they are entitled to, my lord. It was tested before the Honorable Supreme Court of India, my lord, and the Union of India, my lord, had filed the SLP. The SLP came to be dismissed, my lord. At page number 66, your lordship will get it, my lord, get the order of the SLP, my lord. When it states, my lord, there is no grounds urged by the Union of India, and hence the appeal was dismissed. Now, my lord, the learned single judge, my lord, comes to the conclusion. So you are seeking some benefit of 20%. Please, my lord. Or who are you today? My lord, one of the appellant, my lord, is age 90. One more. Then they have got additional pension, my lord. They have got it from the direction of learned single in your favor. No, my lord, he has dismissed our petition. Where is that page? My lord, your operative portion is at page number 16. 16. I'm 16 on. The learned single judge, my lord, refers to an order of the division bench. Yes. Where it states, my lord, in one other case, since they had already completed the age of 80 years, the matter came to was rendered infructuous. Referring to that, my lord, my matter has been closed. But the order of the Honorable Supreme Court, my lord, as well as the Guwahati High Court, which was held in my favor, has not been considered, my lord. What is that order? My lord, the operative portion has been culled out, my lord, here in page 16. May I read it, my lord? It is submitted that the petition could be disposed of in the light of the subsequent development. That is of the applicant attaining the qualifying age of 80 years. That initially the representation was resisted as the applicant had not completed 80 years, and that only such of those applicants who had completed the age of 80 years were entitled to the additional quantum of pension of 20%. That the said issue has attained finality in WP 18753 of 2011, and that the applicant has now completed the age of 80 years, his request for additional quantum of pension would be considered in accordance with law. My lord, during the pendency of the writ petition, my lord, in that particular case, in view of the subsequent development, my lord, since they had completed the age of 80 years, my lord, the additional pension was given. But in this case, my lord, my contention is that after I complete the age of 79, as on the first day of my 80th year, my lord, I'm entitled for the 20% of the pension, my lord. That is my case. So you're entitled to the 20% benefit before 80 years? Not before 80 years, my lord. As on the completion of 79 years, as on the first day of my 80th year, my lord, I'm entitled to. Because the government order says, my lord, I may once again go to the government order, my lord, which I read it to your lordships. when he attains the age of 80 years, that is what is specifically been stated in the government order. But they want me to complete the age of 80 years. I say, my lord, I am entitled from the first day of my 80th year. Notice returnable on 23rd July.
Lord, I take notice for all the respondents. I take notice for all the respondents.
All the respondents. Please, much obliged.
Previous matter. Liberty may be because I will be a remediless.
Liberty to go to the Supreme
Civil court. Dismissal will not come in the way.
What liberty? What liberty you want?
To approach the civil court at least.
Approach civil court. So it is already given. So withdraw it. We'll
Dismissal
give
will not,
liberty, all liberties, wherever you go, with liberty you go.
dismissal will not come in the way, like, at least to that extent.
You go to civil court, district court, higher court. We
Because there is a bar, my lord, under the
They are
act.
very clear that we are dismissing, but liberty will be reserved. Liberty is already reserved by learned single. Still will reserve again and again. We'll reserve liberty. Anything more?
No.
We'll reserve your liberty for it.
Please.
It's number 18.
For
Sudeep,
the appellate
VC.
matter.
That pension matter we can take them early.
My lord, I'll just get the
Take the all.
instructions, my lord.
He
and I-
appears to be right.
My lord, the only issue is, does he get it after the completion of the 79th year? Or immediately when he, my lord, attains 80 years? I'll just seek instructions and make my submission.
So when he enters the 80 years, he attains the 80. Attainment
is
of
what-
80th year. then.
First day of the 80th year.
So give me for reading. We'll little early, we'll keep. We'll keep it on, so that we not forget the subject matter. 11th July.
Very nice.
Give me to read.
My lord,
Convey to the council.
Yes.
Yes.
Number 18.
I
Sudeep,
filed an
VC.
application, my lord, for regrant
This is
of
the
the land.
Lord, this may be called
Part of
along with
group.
it appeal
Group.
210 of 20.
Notice, 3rd July.
Number 19. HS Santosh.
Your Lordship, kindly. My lord, the cancellation order of the allotment of site was challenged before the learned single judge, my lord. An order under challenge is at page number 14. My lord, the allotment letter was cancelled. My lord, and the communication was made to the appellant on 14/7/2003, which was not served. It was returned back to the authority.
After 12 years. Some allotment of site.
Yes, my lord.
You did not respond on the ground that some family circumstances.
Family circumstances, and also, my lord, the
That was valid for only 1 month. And then you spent 12 years in not.
Your Lordship may kindly appreciate this. The communication, my lords, of allotment was made on 14/7/2003 by the authority. My lords, that communication was not even served upon the appellant. It was returned back to the authority with a shara that no such addressee in the said address, my lords. Thereafter, no other communications were made by the authority, my lords. It is observed by the order, by the learned single judge in the order of page number 14, my lords, paragraph number 6.
So the site allotment on what basis?
Its application was made
Hmm?
by the appellant on 3/2/1992.
Allotment of site was for what purpose? What was your right to be allotted?
My lord,
Or what
the-
was the reason to be allotted?
my lord, the notification was called for.
Third learned advocate, Mr. So and so for the appellant, sorry, and learn, anybody appear? For the appellant, the present appeal under section 4 of the Karnataka High Court Act 1961 is directed against judgment and order dated 20th February 23 of learned single judge, whereby learned single judge has rejected the petition. In the writ petition, what was sought to be challenged by the appellant petitioner was order cum endorsement dated 16/11/2015, thereby the allotment of site to the petitioner came to be cancelled on the ground that despite passage of long time, the petitioner failed to obtain a sanction letter under Rule 19/1 of the sanctioned rules of 1991. The site came to be allotted to another person and Hak Patra was accordingly. Hak Patra was also accordingly issued. Full stop. The petitioner prayed to set aside the said endorsement from order. Full stop. It appears that the petitioner had, under a scheme of allotment of sites, applied for a site on 30/8/1992 by making application to the respondent Mysuru Urban Development Authority. रूल्स 1991 आता है ना, इसमें रूल पूरा नाम लिख लो, Karnataka Urban Development Authority, indicate allotment of sites, rules 1991. And further, the allotment of sites is governed under the aforementioned rules of 1991. It is recorded by learned single judge that allotment letter dated 14/3/2003 addressed to the petitioner came back with with postal endorsement that no such address was found. The applicant the LOT petitioner was enjoined to complete certain formalities in relation to the allotment letter within stipulated time. Full stop. As per the rules, as recorded, it would not permit the extension of time beyond 90 days. Paragraph. The petitioner LOT failed to deposit the amount required to be deposited, within the time. Consequently, it lost the right of allotment and right to seek the alternative site. Full stop. As stated in the impugned order, the site came to be allotted upon cancellation to another applicant, and Hakpatra was also mutated. What was sought to be contended on behalf of the petitioner that there were 2 deaths in the family. Therefore, the petitioner could not attend to the process of allotment. Full stop. The petitioner's own evidence show that the death was occurred. Death of mother and the brother took place on 8/8/2003 and 18/8/2003. The allotment was cancelled on 14/7/2003. The first representation which the petitioner made was on 5/8/2015. For a long time, petitioner remained inactive. Full stop. His plea that he was not aware about the allotment was not liable to be countenanced. Paragraph. Learn a single judge observed thus, extracting from paragraph 7, this quoted paragraph, quoted from paragraphs. Paragraph. Quote paragraph. Next. The submission of the petitioner was recorded that it was due to deaths in the family that the petitioner could not approach the respondent, Mysore Urban Development Authority, within time. In this regard, on a single judge recorded following finding in paragraph 8. So bracket was, it is to be noted that even after the reasonable time, the petitioner failed to approach any relief. To stop the reasons supplied by law in a single judge paragraph after quoting is eminently just and proper. To stop. Delay of 12 years on part of the petitioner was fatal to claim any relief of allotment. Even otherwise, the allotment could not have been claimed as of right when the formalities of depositing the amount, etc., was not completed. No error could be booked. Paragraph. In the judgment and order of law in a single judge, the appeal fails and it is dismissed.
Agent, number 21, Mr. Gajendra C.
My lord, this can be called with writ appeal 210 of 23, my lord.
Mr. Gajendra C.
Serial number 21. 20 का क्या हो? Time. 20 can go to 22nd July. 22nd July.
Please. My lord,
21.
21. My lord, this is the SC/ST matter,
Which one?
21, serial number 21.
Nikanti,
Yes, 3rd of July.
3rd July.
So, still number 22. The Nagaraju.
Yes, what is it about?
Lords, we have given the schedule, my lords, for the elections of the cooperative society. By way of a memo, my lords, the schedule is submitted pertaining to the election schedule.
Lords, the appeal was filed only on one ground. The administrator took charge on 27/10/2023. The maximum period for which the administrator is under the statute permitted to hold a particular cooperative society is 6 months, within which time he has to conduct the elections. However, the learned single judge, while disposing of the matter, directed that the elections should be held by July 2024. To be precise, my lords, if your lords were to take the orders of the learned single judge, by 4/7/2024. This is the date fixed by the learned single judge. The limited 4/7/24 at page number 16, running page 16. But our only grievance before this honorable court by filing this writ appeal is that the learned single judge could not have fixed a date for holding the elections beyond 6 months from the date on which the administrator took charge. That is from 27/10/2023. This is all the case with which we came before this honorable court.
So 4th of July was beyond 6 months.
Yes, that is the time fixed by the learned single judge. Then, Lords, your lordship said,
According to you, it fell outside 6 months.
Lords, it falls outside because from 27/10, it should have been conducted latest by May.
27/10/20.
23, my lords, 27/10/23, 6 months, my lords. 27,
by April.
By April, they should have finished.
They should have finished. That's all the grievance.
26th April is their case.
To the term of the body.
Please, my lords.
Term of the body.
Lords, term of the board expired admittedly, my lords, on 27/10/23 when the administrator has taken charge. This administrator has taken charge under 28 capital A5. Once the term of the board is over, automatically, my lords, the board is superseded by the appointment of an administrator statutorily under 28A5. It is deemed. So from that date, 6 months is the date prescribed under 29B, 28B. Now, the government has come up with a proposal saying that they will conduct the elections on 10/11/2024. The first and foremost thing is, appellant cannot be reduced to a worse off or a much worse situation than what he was placed on the date when the writ appeal was filed, when the government has not challenged the orders of the learned single judge. The most they could have done is they should have complied with the orders of the learned single judge. I cannot be put into a disadvantageous position when I prefer a writ appeal. It is something like I prefer the writ appeal and then the order is passed against me. That's essentially what the government is requesting your lordships to do, number one. So this cannot be done. Second thing, my lords, there is some mischief which the government intends. Lords, the first notice, if your lordships have this schedule, my lords, which is given, I'll just take your lordships to the schedule and indicate, my lords, as to what is this mischief which the government intends, which is statutorily not permissible. Mischief essentially is a legal mischief.
What is the mischief?
Lord, the mischief is, after the orders of the learned single judge was passed, which was on 22/1/24 is the orders of the learned single judge. The administrator issued the notice as mandated under Rule 13D2A2 on 29/1/24. Lords, if your lordships were to take page number 65 of the additional documents filed by me, minutes. Lords, I'm sorry. So I take your lordships to two pages, minutes in this, because there is something more than what the eye meets with the manner in which the government is handling this particular cooperative society. Notes page 58 is the first notice issued by the administrator on 21/12/2023. At page number 58.
Of violation.
Notes of this documents furnished by me on 35/2024. Lordship gets it, notes. Sorry. Page number 58. File ಮಾಡಿದೆ ಅಲ್ವಾ?
Which page?
ಇರ್ಲಿ.
Deserves to be changed. Not getting end document.
ಕೊಡಿ ಅದು.
So every submission starts from page 1, separate page, not running page. Subsequent paperwork starts from page 1.
First paragraph, with reference to the above subject and reference in connection with the elections of the Board of the Management of the Tumkur Cooperative Producers Societies Federation is to be held for the period 23-28. The date of elections is tentatively fixed on 4/7/2024.
Oh, where you are reading?
Lords, page 58, the fourth line, Lords.
50?
58, 58.
Yes. What is it? Notice.
Yes. Notice under 13D22A2. This is issued by the administrator. After the administrator has taken charge, on 27/10/2023, they issue this notice, fixing the date of election on 4/7/2024, which is the date fixed by the learned single judge for holding the elections. Now, after this notice is issued, then we have come before this honorable court stating that election should be held in the month of April, not in the month of July, as directed, because 6 months is the window period. What they do is they issue one more notice, duplication, at page number 65. Tentatively fixed on 12/8/2024. Same provision.
So why it was postponed?
Notes, this is the reason why I am submitting. If the elections were required to be held on 12/8/2024 or by July 2024, they could have accomplished it because code of conduct was over by the 6th of June itself. This is after that they should have held it.
Code of conduct was over on?
6th of June, 6/6. The process would not have been affected, Milords, with this code of conduct because these are all some administrative work which would be undertaken under the provisions of Rule 13D2A. 4th of July, they could not have breached this mandate for conducting the elections when the orders of the learned single judge, Milords, is staring at them. Milords, not being satisfied with this postponement, now they come before this honorable crime. I should really appreciate, Milords, their courage in doing this when the orders of the learned single judge is staring at them that they have to conduct the elections by 4/7. Lords, may kindly have a look at the schedule which they have given now. They want to issue the notice on 16/5/2024 once again. Where is it contemplated issuing this kind of notices?
Read the schedule.
It's filed in the memo, my lords, dated 28/5/24. 28/5/24, annexure R1, my lords.
Let's kindly have a look at this. 16/5/24, again, they want to set the clock once again. Notice the statutory mandate is that elections are required to be conducted before the expiry of the term. Then this 13D2A controversy came about, and this was held by, which was dealt with by the coordinate bench minutes of this honorable court, held that 13D2A is mandatory. It is to be complied with. So only requirement is 13D2A has to be complied. How it is to be done is also already spelled out. The provision itself is very clear. 13D2A notice will have to be issued 195 days prior to the date on which the proposed election is to be held. The election is required to be held. From that stage, the process starts. So if we take the date on which the notice is issued as 21/12/23 or the latest notice on 29/1/2024, they cannot give a schedule which is later than 195 days from 29/1/2024, which would be August latest. But my grievance is something else, because the state cannot be permitted to play around like this for any contingency for that matter. Lords, may kindly have a look at section 28A for a minute, Lords, of the Karnataka Cooperative Societies Act. (28A) subsection 4. Subject to, your lordship gets it, subject to provisions of 29A and 39A, the term of the office of the members of the board shall save as otherwise 5 years from the date of the election, and they shall be deemed to have vacated the office as such members of the board on the completion of the said term. So we will cease to be the members. Then what is the consequence? 28A5, subsection 5 of section 28 capital A. If the new board is not constituted under 29A on the date of expiry of the term of the office of the board, or if the elections are not held within the time limits specified in 39A, the registrar or any other officer within whose jurisdiction the society is situated and who is authorized by the registrar, Lords, may kindly mark the words, shall be deemed to have assumed charge as an administrator, and he shall for all purposes function as such board of the management. The administrator shall subject to control, so on and so forth. I'll not trouble your lords with it. So the term ended and he is taken charge on 27/10/2023. Then what follows is 28B. Notice 28B1 is the mandate that it should be held before that date. Then your lords may kindly come to subsection 3 of section 28B. The administrator who shall assume charge under subsection 5 of section 28A shall as early as possible, but within a period of 6 months, arrange for the constitution of a new board of the society in accordance with the Act, rules and the bylaws. Then, provided the administrator so appointed shall not continue for the period beyond 3 months in respect of a society in cooperative credit structure. So 3 months for credit structure and 6 months for the non-credit structure cooperative societies. This period is not capable of being extended. This is the maximum period which has been provided for. So this is the only ground which we raised before your lordships when we challenged the orders of the learned single judge. Now that the writ appeal is pending before your lordships, government has got the audacity to come and say, we don't want to comply with the orders of the learned single judge which we have not challenged. This is essentially the substance of the this schedule which is given by them. They are virtually in contempt of the orders, notes of the learned single judge. It's one principle which is laid down because the Code of Civil Procedure is as much applicable to the writ appeals under Order 41, Rule 22. I cannot be reduced to a worse condition or worse situation than what I was situated as on the date of filing of the appeal. No adverse orders can be passed against me. So therefore, my lords, my request is that the orders of the learned single judge needs to be adhered to. I am reduced myself to a situation where I am pleading before your lordships. Let the orders of the learned single judge, my lords, be upheld at your lordships' hands, though I am in appeal at your lordships' hands. Latest by 2 months, if they were to hold, my lords, I will have absolutely no difficulty because notices are issued. Let them not unnecessarily drag on the matter unless they intend a mischief.
My lords.
Grateful for the hearing, lords.
My lords, 2 points I'll make, my lords. One is the argument of the learned senior counsel that multiple notices are being issued. My lords, that may be incorrect. It is not multiple notices, my lords. Once we issued a notice earlier in the month of January, my lords, we received around 181 objections, where some other milk producer societies who were ineligible were not given notices. Hence, another notice came to be issued
For notices for inviting the
to find out whether they're eligible to vote or not under Rule 13D, my lords.
list of voters.
Please, Rule 13D, my lords. All the ineligible voters were not sent these notices appropriately. These were not multiple notices, my lords. Notices were sent to all. Now, in view of the Lok Sabha elections, my lords, the officers could not conduct the proceedings. And in the meanwhile, my lords, where we have come to know where there are ineligible voters, my lords, this new schedule has been given before my lords, wherein we have issued notices to all the ineligible voters, my lords, and we want to conduct the election in accordance with law, in accordance with the Cooperative Societies Act. And my lords, the argument pertaining to the administrator's term, which is expired within 6 months, my lords, for that, the state has again passed an order dated 5/6/2024, my lords, under section 121 of the Act, wherein the term of the administrators in which elections are not concluded due to various reasons are extended, my lords. It's in Kannada, my lords. I'll give the translation.
So term was getting over when?
My lords, the term would have got over on 26/4/2024. 6 months, my lords. 26/4/2024. My lords, I have just one translated copy. Just now I received, my lords. One is in the Kannada language, my lords. Serial number 5, my lords, is the extension of time of the administrator.
What are you showing?
My lord, serial number 5, my lords, I've passed it on. In the second page, my lords. Wherein the, yes, please, that's the document.
Serial number five?
Please, serial number 5 in the second page, my lords.
That's serial number five.
Please. Wherein the administrator's terms, wherein elections are not conducted, have been extended, my lords. My respectful submission is there is no malice.
This was withdrawn.
Please. No, my lords, that was the earlier one, where in the month of April, order was passed, that was withdrawn, my lords. This is subsequent. After the code of conduct, we have issued this. My lords, there is no malice on the part of the state, my lords, because they have not intimated the state government in time as per law to conduct elections. Hence, we had to step in and do all this exercise. And now this schedule is given, my lords. This is as per the law and as per the dates and time which is schedule which is provided for giving objections, hearing them, and various other things, my lords. We have explained from serial number 1 to 14. And we have also stated that as per the table, the election process would be completed. There is no willful disobedience of the learned single judge's order, my lords, in view of all the subsequent developments, so that everybody gets a right to vote, not just the petitioners before, my lords, where they had not given the proper notices in time. This is the exercise done by the state, my lords. This would be my respectful submission. You may be permitted to adhere to the schedule and complete the process.
So we'll pass orders on
Please.
Tuesday.
Just one indulgence, my lords. Lords, I kindly see the order sheet dated 18/3/2024 in the present matter. Is exactly an exercise which they did at an earlier instance.
One. Order you want to show?
Lords, 18/3/24 of your lordship's order, my lords. Para 2, my lords, of your lordship's order.
18/3.
18/3, paragraph number 2. In course of the consideration of the appeal on the last occasion, the learned advocate so-and-so showed to the court a notification dated 13/3/24 issued by the government, whereby the term of office bearers of the society came to be extended in view of the impending general elections. It was pointed out today that the notification came to be resigned by the subsequent notifications dated 16/3/2024. Similar exercise was undertaken. Lord, this honorable court said, how can you breach the statutory mandate when the statute has fixed the time?
After this rescindment, again.
Again, your lords has passed an order on 8/4/2024.
Again, administrative.
One, lords.
At that point of time, no administrator was
Lords,
appointed.
at that point of time, administrator was already in charge.
His term was still there, existing.
His term was still there, but they wanted to extend the term. Then they issued a notification. I brought it to your lordship's notice. This is what they have done. This honorable court raised an objection. What is this which is happening when the statute says that 6 months? How can you do this?
That you are right.
Less.
There
And
you are
then they said that no, we have already withdrawn. Morning they issued, evening they withdrew. Then kindly have a look at the order sheet dated 8/4/2024. Lordships, grateful for the hearing, lords.
Grateful.
For Tuesday for all.
Grateful.
Please.
Number 23, my lord, the appellant in this case. Lord, this matter was listed yesterday at serial number 23. This matter was listed yesterday. My senior was requested this honorable court may kindly list this writ appeal along with the writ appeal number 331 of 2024, which is the connected. Now, one more writ appeal has been filed, my lord. The learned single judge has passed the common order in both writ petitions. Challenging the same, 2 writ appeal has been filed. One is listed, another one is yet to be listed. Therefore, this writ appeal may be listed along with the writ appeal number 331 of 2000.
What do you want?
Now, this writ appeal can be linked with the writ appeal number 331 of 2020.
To be listed with writ appeal number 330 of 24.
331 of 2024.
331 of 2024. On which date?
Next week date. Next Friday.
On 23rd July.
Lord, this is a matter where there is a delay of 46 years.
Lord, only the writ petition has
Lord,
been
may I have it
writ
next
petition
week,
filed by the
my-
petition.
Yesterday's matter.
Yes,
44
next
years.
week.
Oh.
My lord, we have a citation. My lord,
My lord, may we
my
call
senior
next
will.
week, my lord.
Only one line order was needed.
Please, my lord. Number 28th, Friday may be listed, madam, but senior will come and ask them. Please.
All right, Tuesday.
My lord, Tuesday, we senior has function in, so
Senior
kindly
has gone where?
Friday, my lord.
No, senior has gone somewhere.
No, my lord,
Abroad.
he has some function in his house.
Function is.
Yes.
So when do you want?
28th, my lord. Friday,
Right, today is Friday.
next Friday, my lord.
Friday, you say any Friday,
Coming,
next Friday.
please. Number 24,
Before the appellant's counsel.
This can go to next Wednesday.
On a very short notice, this can be, I'll only take 5 minutes.
But next Wednesday.
Yes.
I have not applied my mind, so.
Yes, yes.
That is the only reason, to be candid.
One issue, my lord, we are together, that a insolvency proceedings against a partnership.
Only
concern-
question, Mr.
Yes, my lord.
is that
Yes, yes. ma'am.
if it is on the face of it,
Yes.
not maintainable, then
The writ petition. The writ petition. That's my argument.
that you have to answer.
Say, the face of it not internal rate.
Wednesday. Wednesday is convenient.
The next Wednesday, if the matter, my lord, there is an arbitration.
That can post.
Yes, my lord, we will make an application to the tribunal for the postponement.
In view of the pending.
So grateful.
My lord, it is in the cross-examination stage, my lord. My friend had already partly cross-examined. And earlier, they have also taken a stand that the mandate is over, which matter went
We
to
are in the middle of the hearing.
Therefore, that doesn't have any bearing. The lordship can say arbitration can go on. They have already commenced and gone ahead.
Let nothing go until it is decided. Why should?
No, my lord. Supreme Court not passed an order saying that your claim of mandate is over is not correct. You have been dishonest in the manner that you have been delaying the arbitration proceedings. After that, arbitration commenced. I have placed that order also. I have showed it to your lordship.
We'll take up letters. Arbitration maybe take time in the arbitration.
We'll
The matter of once we hear and
No difficulty, my lord. Earlier, 3 or 4 occasions, same thing happened. Every time they come up with, that is the reason I pointed out about 7 writ petitions.
Come on Tuesday. Tuesday is which 25th Tuesday.
Published.
So grateful. So grateful.
number 25, P.B. Patil.
I appear for the appellant, my lord. My lord, yesterday three other. My lord, yesterday three other writ appeals were listed. Your lordship was pleased to direct to connect this writ appeal along with them and posted on 16/7. Even this matter can be posted on 16/7, my lord. My lord, yesterday other three writ appeals were listed. Your lordship was pleased to order that this writ appeal should be listed along with those writ appeal and posted on 16/7. Please, writ appeal number 493 of 24. Please, mobilize.
Number 26, Raja L.
This case appear for the appellant. Appellant is challenging the order of single judge order. The petition is filed a writ petition before the single judge. Writ of mandam was made. The trial court only delay and latches is dismissed the writ petition. Hence file the writ appeal made. In the year 1933 is acquire the land for the purpose of road, but there is no compensation award by the government. So several oral submission before the authority, this is not given the compensation. I will the representation given the concerned land acquisition officer to consider the award the amount but even till today, there is no award the compensation. The only delay in latches is dismiss the writ petition, my lord. There is no admitted the fact is the no award the compensation before the authority. Even it, so only writ of mandamus.
Issued on 23/3/1993. In the petition, various grievances are raised by the petitioner. Full stop. The delay is fatal when the acquisition notification had been issued in the year 1933. The petitioners could have hardly a right to relief after passage of such enormously long time. Cause of action could not be said to have been survival at all. Post of law on a single judge paragraph was eminently justified in dismissing the petition on the ground. No different view could be taken. Appeal is dismissed.
So number 27.
Here for the appellant.
Vivek.
800.
Now, what happened to inquiry?
My lord, inquiry was ordered, my lord, by the learned single judge relating to, my lord, something which happened, my lord, 10 years back. In fact, my lord, he says he has issued a notice.
The appellant is High Court.
My lord, appellant is the High Court, my lord.
So
Here-
why High Court is here?
Please, my lord.
Why High Court is here?
Because reason is, my lord, there was, my lord, grave misconduct on the part of the fourth respondent. In fact, if your lordship just turn to, my lord, running page, report, my lord, at page 384.
No, first let
Sorry,
us see
sorry.
the prayers in the petition. Prayers in the petition, page 103.
Yes, my lord.
Directing the respondents to take steps to remove the report news under heading Judge
Judge
guilty of
unacceptable. My lord.
unacceptable
I'm not
intimacy
agreed
with
by that.
steno, HC,
Yes.
so and so, so and so.
Yes, I'm not agreed by that.
Not-
I'm only agreed by an inquiry that has been ordered in relation to something, my lord, which happened, my lord, 10 years back. High Court has to hold an inquiry. Page, my lord, 48, 48, bottom. High Court in its counter has not denied the receipt. This is also not correct, my lord. We have produced, my lord, the memo. Please, 48, my lord, 48, internal page 29 of the order. High Court in its counter has not denied the receipt of legal notice. In response to the reference to notice which was made in para 20, there is also no record produced to indicate this request of the petitioner to conduct an inquiry was considered. In case where the senior judicial officer alleges an inquiry report in which allegations of impropriety has been made against him was leaked to the press and had been published before it was even accepted or rejected by the disciplinary authority, it would be in the fitness of things and a duty cast on the High Court, etc. Now, my lord, please come to, my lord, page 811. High Court has denied having, my lord, received this notice. My lord, look at the last para, my lord. My lords may come to, my lord. Yes, my lord. Para 63. Subject to the directions to the third respondent, 13th respondent to pay costs to the Karnataka Legal Services Authority and direction to the High Court to hold an inquiry with regard to the leakage of the inquiry report to the newspaper report. He wanted, my lord, Justice Kehar Singh, former Chief Justice of India, to be made a party, Justice Vikramjit Sen, and, my lord, other judges, sitting judges. And, my lord, the inquiry means, my lord, in fact, my lord, he filed an application. This honorable court rejected it. This is not even the prayer. That's what we are before your lordships. Precisely, my lord, why? My lord, he says there was a note. Para 39, if your lordship sees, notice was issued according to him, 811. And we did not reply. That is also not correct. That notice was never received by us. Page 811. What happened? That is, my lord, the report of the inquiry. Sorry. Lord Rajendra. Please.
Number complaints in contempt matters number 28, Mr. A.V.
I
Amar.
pay for petition, complaint, Mela, complainant number one is expired, Mela, let to file necessary application, this, Mela. And they, on the last date of it, the respondent was directed to file a appropriate affidavit, Mela, they're not filing. It was on 12/7/22. I'll file my applications.
My lord, I have just one submission, if your lordship permits. The order which had to be considered, my lord, there was only an order to consider the representation of the petitioners in the year 22. That is the order of the learned single judge. What we have done is we have filed our compliance report and we have said that they do not meet there was a circular order also given by the state of Karnataka dated 18/10/2021. In that order, my lord, these petitioners do not, they attained superannuation before that order was brought into force. And therefore, my lord, we have given an endorsement saying that they are not entitled to the enhanced pay scale. Now that they have, to that, they have filed a rejoinder to the compliance affidavit, stating that that is not any compliance. My lord, my only submission is, now there are, my compliance report, annexure R2, my lord, if your lordship could see for a moment.
Expired, first complaint expired. Mela, there was a direction to file additional affidavit, Mela.
I
Then
only-
they're not filed.
I
The
only-
submission was recorded, it was not proper, that's why they were directed to.
My only submission is the
Number-
compliance is done and that is furnished by, in this honorable court, my lord.
Number 29, the suo motu writ petition.
This matter relates to, I'm as acting as the amicus, relates to implementation of the provisions of right to children, my lords, for free education. There are several orders passed by this honorable court. But the last of the orders, my lords, in one order, the government was directed to conduct a survey, my lords, of all the schools to find out about government schools, my lords, about the drinking water facilities and toilets. Based on that, they, in the presence of, my lords, a member of the Legal Services Authority. Then they have filed a report. We have filed, I filed a status report showing certain shortcomings. The government has said they'll look into it and come out with that. Identically, my lords, an order came to be passed by this court, my lords, on 9/10/23, directing BBMP also to conduct the survey and give a report. BBMP, my lords, had to take the same services of the Legal Services Authority personnel and then conduct a survey. Now they have furnished a copy of the report to us, which does not say anything except saying all toilets are available, some drinking water facilities are available. That may not be in tune with what this honorable court had initially passed, my lords, on 22nd of June 2023. The last order by this court was on 11th of March 24.
My lords, I appear for respondent number 4, the impleading applicant. in this matter, the Azim Premji Foundation. We have not been served with a copy of the BBMP report. Kindly direct them to serve us a copy so that we may be also be permitted to file our response and reply.
May I make a submission? I appear, my lord, in these proceedings in not an application. my lord.
BBMP has now filed a report. I do not, they have served a copy on us, but I don't know whether they have placed it before the
Yes, it has been.
court. Education Act. My lords, if your lordship sees the order, the first order, my lords, of 22nd of June 2023. That's, my lords, that assumes importance as of now. 22nd June 2023, my lords. In that, please come to, that's a very lengthy order, my lords, of 22nd June 23, but please come to para 25, my lords, in that order. Yes, ma'am. It said, considering these aspects, we deem it appropriate to direct state government to conduct a fresh survey of the schools. In the process of such survey, the school authorities are to see that the Secretary of Taluk Legal Services Authority of the particular Taluk is a necessary party for the conduct of survey. Exercise of conducting survey completed within 3 months and the report be submitted before this court, duly signed by the Secretary of the Taluk Legal Services Authority. Now, this came about because, my lords, the state had filed its report, which was considered prior to this exercise, which was considered by this court and found that their report was not showing the actual ground reality. So the Legal Services Authority was directed to be, my lords, made a part of the survey team. Thereafter, the state government, my lords, filed its status report, which was signed by the Legal Services Authority team. The survey report, my lords, was filed on 11th of December 23, for which I have filed a status report showing that in spite of it, there are certain shortcomings, which the report itself shows that there are in some places, there are no toilets. In some places, there are not even drinking water facilities. Then, my lords, this honorable court also noticed that there are government schools within BBMP limits, which is managed by BBMP. So based on that, another order came to be passed on 9th of October 23, where BBMP was directed to conduct such an exercise. 9th of October 23. In that, if your lordship kindly come to para 8, my lords. In that, please come to para 8, my lords. Prior to that, they record everything. But para 8, my lords. Yes, my lords. At the request of learned additional government advocate, we reluctantly grant a period of 8 weeks to accomplish the survey of the government schools in question and also schools run by Bruhat Bengaluru Mahanagara Palike place the report before this court. Needless to state that the respondent BBMP to submit its report regarding the schools being run, monitored or supervised under its authority. We again make it clear that the comprehensive report should contain all material particulars and complaints of the measures taken for granting redressal on a war footing in as much as drinking water, toilets, washrooms, and the like are not only the infrastructural requirements, but basic needs in any civilized society. Now, BBMP has filed its report, if your lordship sees. The report, my lords, is not, they don't co-op. The report, my lords, is dated 5th of June 24, which is furnished to me.
8th of April.
BBMP.
That's what I'm saying.
Yeah. BBMP is 8th of April.
8th of June. 8th of June, ಹಾಕೇ ಇಲ್ಲ.
8th of June ಹಾಕಿರೋದು. 8th of April.
My lords, state in respect of other schools, within the limits of the BBMP limits, BBMP is managing. So BBMP has filed a report, my lords, at least the copy which is furnished to me is, my lords, dated 5th of June 24. BBMP, I don't know whether it's been placed before my lords.
That's been filed on 8th of April, my lords, before my lords. It's filed on 8th of April. It contains 2 volumes.
That copy has not been served, but lordships is there. The report is.
I haven't been served.
I will serve a copy, my lords.
My lord,
Because
I have-
what they have to show is toilets for girls and boys also. Because what we are seeing is, my lords, they only say toilets. And the Taluk Legal Services Authority representatives does not seem to be present in this exercise.
8th of April.
Yeah, of course.
8th of April.
Let's filed it on 8th of April. Yes, my lords. Yes, my lords. Let's. I shall have. Then I shall. Let's. Contains a table at page. My lords, then.
Where is the report? I don't find any report.
For me, what chart they have furnished?
Let's. I'll have this.
The report which was directed to the. There is no report except producing. Who is the commissioner?
Let's.
I don't know how to respond to the court's orders.
I'm sorry, my lords.
Scoring. Is this the report, Mr. Counsel?
Michelle.
It's a very important matter and you're producing such a, showing the photograph. Do you mean what is the report?
Yes, my lords. My lords, this is.
And you're just throwing this one.
My lords, I shall file a proper report in a short accommodation provided. A week's time may be granted, my lords.
Totally neglecting the court's order.
Your Honor, I'm party in
But
person.
may I make one submission, ma'am? I'm not able to see the honorable court.
No, he is, my lords, in this matter, not in relation to BBMP. My learned friend has another issue.
Lord,
Not.
Lord, some students, my lord, have filed an application before the honorable court, my lord, in IA number 1 of 21 for intervening.
My lords.
They are, my lord, Mr. Nayak, my lord, appears for them. I am opposing that, my lord. What has happened is.
My lords.
This.
I understand, my lords. This was prepared not during my time, my lords. A week's time may be granted. I will file a fresh report, my lords, which would satisfy this court.
My lord, if I'm
22/6/23. Then, my lords, the other order was on 9/10/23. Lords, the first order to conduct a survey was on 22/6/23 with the Legal Services Authority.
That was for the government, my lords. For the BBMP, it's on 9/11, 9/10.
It was a part of the government.
My lord, if I can make one submission with your lordship's permission.
The direction to BBMP was given on 9/10, my lords.
Para 25 said all schools, government came out and said, BBMP schools, we are not concerned.
My lord, if I can make one submission, my lord.
Petition.
All schools, man.
Schools,
all schools.
all
From
schools.
0
my lords.
to 18.
That's up to high school, my lords. It is from
Up to UG and PG as well. My lords? SH Prashant, my lords.
by the BBM. This report is by, he is appearing only for BBM.
My lord, if I can make.
My lords? It was filed on 8th of April, my lords.
When you will file a report rejected?
In a week's time, my lords. Yes, my lords. Yes.
Lords,
My lord, if I can.
I don't.
Great, I will do that, my lords.
Lords, they have to conduct a survey with the.
Yes, my lords, I understand. Yes, my
Ah.
That.
Your Honor, I am party in person. I also wish to make a submission. My lord, just one submission, if I may.
I'm sorry, my lords. This would repeat it.
My lord, if I can make one. My lord, just one submission with your kind permission. This is a serious matter with.
I shall assist better in this matter, my lords.
My lord, just one submission. This matter has been going on since 2013, my lord, and this is an important, serious matter with regard to ensuring that the right to education reaches children from 0 to 18 years. Now, there are a sea of directions by your honorable court to the BBMP as well as the state government, and the party. Please, my lord, we have filed our report on 11/12/2023. No, I'm not saying,
No, it is.
For a moment, I'm not saying it's better, my lord. My only submission is there are different, I want to just suggest, my lord, there are different departments over here who are involved. A pair, no, my lord, Urban Development Department, the Child Welfare Department, as well as the Labor Department looks into these issues with regard to the education of child from 0 to 18 years. So there was a integrated, coordinated committee which was constituted, my lord, to look into the periodical dropouts of school, children from school, and to ensure that this is taken care of by the government and the various departments. So my only suggestion to your lordship is, if there can be that meeting conducted where all the stakeholders come, look into the issue, and then address the honorable court, my lord. Your Honor, I'm party in person in this case since 2013, and I have made several submissions, and my last two memos were dated 20 2nd of January this year, and also on 8th of April this year. And they were supposed to conduct this IDCC meeting, Interdepartmental Coordination Committee meeting, to submit their report, compliance report about the memo that I have submitted.
Lords, she had
So I have
furnished-
not received any report from them. Committee has, was held last in April, my lord.
Lords, the copy of the memo was given to me also. It has been filed. We have pointed out, I have filed a status report showing some deficiencies. Yes, that has, through the legal, that, my lords, at least they have taken legal services authority personnel and done it. BBMP, my lords, is absent in that. Anyway, they have to, my lords, otherwise no point. They are giving us only.
Your Honor, I have raised several other issues. Your Honor, I have raised several other issues to which they need to respond. A meeting was held in place of the.
My lords, BBMP. My lords, that they are not even showing us correctly, but in their status report, they show about 85 schools. From what they have given us, my lords. BBMP nursery schools, they have shown 85. Primary is 16 schools. High schools, my lords, from what data they have given, 33. That's, my lords, 33. My lords. And also toilets for girls and boys. They only say toilets. We do not know. That's why, my lords, last occasion, the court directed even the legal services authority should be a part of it so that.
May I just submit, my lords? The pre-nursery schools under BBMP are. My lords. All right. No, my lords, lordships posed a question, how many schools are there? I just want to assess that. I'm sorry, my lords. Yes, please. Yes, please.
Your Honor, I wish to request that you direct them to submit a report about my memos, their compliance report to the issues raised in my memo. I would like to read my memos.
No, my lords,
It's
party in
part of
person
this.
as to assist the matter.
Your Honor. I represent an NGO called Civic. Yes.
Sit. We'll get confused.
That's what has happened. She has pointed out certain queries pertaining to certain moot points. Many of those queries have to be answered by the government. So, my lords, from the amicus, the court had asked me to look into it and come out with suggestions. A few suggestions have. And once they file a, my lord, then we can take.
Kindly direct them to do so, Your Honor, on every point that has been raised.
That the state has to answer. He has, lords, her queries are to the state. State has to answer. Even I have as a amicus, I have addressed. Yes.
Is for the state as well as the BBMP, because certain schools come under the BBMP and certain. please, I will file my report, my lord. My only suggestion was that if all the stakeholders can get together, and because there are 5 departments who are going to be looking into this issue. My lord, we have filed one report on,
ಇಲ್ಲಿ ಬಟ್ಟಿಟ್ಟು ಸೈನ್ ಯಾವತ್ತು ಹಾಕಿರೋದು ರಿಪೋರ್ಟ್ ನೀನ್ ಇದು ಮುಚ್ಚಬೇಡಪ್ಪ ಯಾಕೆ ಮುಚ್ತಾ ಇರ್ತೀಯ Their first report is filed on 11th of December 23. It's in volumes.
11,
They are filed
12,
11,
20,
12, 23. It's a bulky report, my lords. I don't know whether my lord, it runs into volumes.
we have filed, in fact, my lord, I was given a, no, my lord, in fact, the department had come and they've given me a bulk of papers, which I need to go through. However, I didn't want to file it because.
Please. Please.
Yes.
If I may go through the prayers made by me, Your Honor. The prayers made by me, whether I can go through that with your kind permission. Actually, one meeting was held supposedly of the Interdepartmental Coordination Committee on the 8th of April this year, but it was supposed to be held under the chairpersonship of the Chief Secretary, but it was not held under his chairmanship. The additional Chief Secretary of the Development Commissioner held the meeting, and she gave a series of directions to the various departments to come up with a report on the issues raised in my memo, but nothing has come out from that. They have sent the minutes of the meeting, but not a report.
Please.
Yes. Yes, please.
Whatever report that they file before the next date to serve a copy upon all the parties so that we may also be permitted to file our response.
Yes, Your Honor, the reports are not being filed to the party in person also. No, Your Honor.
Yes, ma'am. I'll serve a copy.
Yes, Your Honor. Thank you.
May I make one submission, Lord, is incidental to all of this, but I've been dragged into this litigation.
You are for whom?
My Lord, I appear, my Lord, for the Ramakrishna Ashram. Lord, one set of students, 22 of them, filed an application, my Lord, to intervene in these proceedings. There have been a host of proceedings so far as that is concerned. A piece of land, my Lord, was given to the ashram to build a Viveka Smaraka in Mysore. That, my Lord, 3 litigations have ended unsuccessfully for them, and the courts have upheld the grant of land to me. But taking note, cue of the pendency of these proceedings, they have filed mischievously an application IA-1 of 21, raising number of issues which are all covered, my Lord, by judicial decisions. So I have, my lord, filed a application and filed all these documents. So IA 1 of 21, my lord, whenever your lordship pleases may be heard, it has to be dismissed because that very issue is gone into and decided against them by this honorable court. They're mischievously trying to, my lord, keep that issue alive by filing application in this.
Intervention application by a third party, my lords. What my
Some-
learned friend is, that can be taken up or
Intervention of
next
the
date.
students.
Lords,
Yes, my lord.
Is there one school was?
It may not be
transferred.
necessary.
Yes.
That's not necessary at all.
We are for students, but students are not necessary.
So this IA 1 of 21, my lord, may not be, may be disposed of, my lord, because they are not seeking any of these reliefs.
Let us see on that next.
Dependency of this is being misused by them, my lord. Everywhere they are going and saying that the matter is pending, the building is being built, and we are spending crores of rupees on the building. Government has granted that land to us.
Withdrawal of writ appeal, seal number 80, Mr. Rambhat K.
Lords, I appeal
Memo
the
filed for withdrawal.
matter.
Memo filed for withdrawal matter.
Learned advocate Mr.
For respondent number 2,
seeks permission to withdraw the contempt petition in view of the memo dated 5/6/24 filed by him, under which he is instructed from the complainant to withdraw the contempt petition, full stop. The directions of learned single judge committee stated are complied with.
And there is excess monies available in the bank. Excess sale money is available in the bank. That liberty may be given
What liberty?
to
Before.
approach the bank and because otherwise they may raise
My
some
lord,
objection.
I appear for the bank. I have not been served with a copy of the application, my lords, for withdrawal, and I oppose any liberty.
Then you don't have the copy of memo, madam?
My lords, I don't have a copy, my lords. It has not
You
been.
copy then, first
Please,
and will.
I'll serve.
Tuesday.
My lords, I'm not opposing the withdrawal. I'm only opposing the liberty, my lords. Your lordships may.
Go through the memo then.
I'll serve.
Tuesday.
Please, ma'am.
My lords, may I request
Tuesday
for
at
a
2:30.
passover, my lords?
Tuesday at 2:30.
Very well.
There's a copy may be directed to be served on respondent number 2 as well. I have also not been served.
26th then.
Very
2:30.
well, very well. Grateful.
Passover matter, seal number 75.
Just a short list of dates. I may be permitted to go through the sequence of events what has transpired in this matter. 12th January 2024, my lords. FIR was filed by the High Grounds Police Station with
You give the facts because.
these are the facts, my lords. These are the facts what I've.
So these facts are giving from the middle. Give
No,
from the beginning.
From the beginning itself. 12th January.
All right.
From the beginning.
Now, these licenses are given for some specific period.
Well, what happens, my lords? They've got a chart of the race, my lords, as per the rules, my lords. They had filed an application till the month of August, January, February, March, April, May, June, July. The applications for a monthly wise, they had filed their application for grant of license, my lords. For
license is given for how many months?
There's no specific month by month, my lords.
Period is specific.
Specific period is specific, my lords.
What is that normal period of license?
Even though the act says for 1 year, my lords, but what we give is per month to month, my lords. As when they file the application, that is given, my lords.
Month to month.
1 or 2 months, my lords. That your lordships will get it, my lords. Your lordship, can I permit, give the act and the rules for your lordship? One more copy act.
I'll let you go in your own way.
No, I'll just,
Yes.
I'll answer
12
your,
and 20. Yes, yes.
I'll
Don't
answer
worry.
your lordship's question by the act and the rules so that then we can proceed.
Yes. You proceed in your own way. Don't worry. Yes. Yes.
What your lordships, under the act, section 4, my lords. Section 4 speaks about licenses. A license for horse racing, the owner, lessee, or occupier of a race course may apply to the government or the officer authorized by the government for a license for horse racing on such race course or for arranging for wagering or betting in such race course on a horse race run on some other race course, either within the state or outside the state. 4.2 is important. The government or the officer authorized by the government may withhold such license or grant it subject to such conditions and for such period. This is what your lordships ask query, for such period as they may think fit. Clause 3, in particulars and without prejudice to the generally of the foregoing power, such conditions may provide for payment of fees, all this, my lords. Then clause H is important. Such other matters connected with horse racing, maintenance of racecourse of which, in the opinion of the government, authorized by the government, it is necessary or expedient to make provision in the license. Then clause 4, my lords, 4 subclause 4. My lords got 4 subclause 4, my lords.
Yes.
I'll skip 4 subclause 5, my lords. The government or the officer authorized by the government may at any time suspend, cancel.
Now, government or officers authorized by the government is not there, which you are reading.
That was an amendment. Probably in the book, it is not printed now.
Book. There's an amendment. These are the
Amended
two.
in 2020. Even in this book,
Even
I
in
have
that
the
book,
same
your
book.
lordship will
Even
not-
in this, that amendment is not included.
Though it is a 23 edition, the amendment is not.
So you are the only person having amendment.
Only one spare copy.
No, if something is material, these
No, I
words
don't
may not
think-
be much important, but
I don't think anything much-
material.
Except that word appropriate authority.
Government or any appropriate person authorized, it says. Only that or authorized person is added.
All right, then we'll see. Yes. Yes.
4.5, my lords. The government may at any time suspend, cancel, or modify any of the conditions specified in any license or permit. Therefore, my lords, from the reading of the act, my lords, it's very clear that the state government can withhold the license, suspend, cancel, or modify the license for such period as it may deem fit, my lords.
Yes.
And section 8, my lords. Section 8, saving of orders, the granting, refusing or cancellation of license and the conditions subject to which a license or permit is granted shall be within the discretion of the government or the officer authorized by the government and shall not be liable to be called in question in any court. So therefore, my lord, the decision of the government to grant or refuse to grant the license, my lords, is final.
Yes.
Then, my lords, if I may request, my lords, the rules, 1952 rules, my lords. That's the next rules I also have given, my lords. Rule 3, my lords. They contemplate two types of license, my lords. One is horse racing license and second is betting license. Rule 3 speaks about horse racing license, my lord. An application for a license for horse racing on any race course shall be made to the Secretary to the Government of Karnataka, Home and Revenue Department in Form 1 and shall be accompanied by, I'll just skip that one, the description. Rule 3A, an application for a license for arranging for wagering or betting on a race horse or some other race course shall be made to the Secretary of the Government of Karnataka Finance Department in Form 1A, shall be accompanied by the Government Treasury, receipt in token having credited with the prescribed license. My lords, if I may stop here for a moment, my lords. Form 1, Rule 3 speaks an application for horse racing to be made to the Home Department, Revenue Department, my lords. Insofar as Rule 3A is concerned, that is wagering or betting, that has to be filed before the Finance Department. That comes in Form 1A. So there are two, the rules stipulate two licenses to be obtained. One is horse racing and one is wagering and betting. Then Rule 5, my lord. The government may call for a report from such authority as it thinks fit, and after such inquiry as it deems fit, if satisfied of desirability of granting license, grant such license in Form 2 or Form 3 as the case may be. So therefore, it is at the discretion of the government, my lord. Under Rule 5, it has to be granted in 2, either Form 2 for horse racing, betting in Form 3. Then Rule 6, my lord. Every license granted under these rules shall be valid for the year ending until the 31st March and be renewed for further period of 1 year. Each application made in writing so and so, own department not later than 3 months from the date of expiry of license. Rule 9, my lords. In case of refusal of grant or renewal of license, intimation of such same be given to the applicant in writing, and the license fee paid shall be refunded to the applicant in the event, my lords, license is not granted. Can I request, my lords, then Form 1, my lords, that next page is Form 1, is application for horse racing license. Form 1A, my lords, that is application for license. If your lordship may kindly serial number 2 in that application, where the application is authorized to arrange betting. So this Form 1 under Rule 3 is for betting, my lords. Form 1A. Form 2 is license for horse racing, my lords. Form 2, which is there, my lords. Then if I write it below Form 2, my lords, got it, my lords. Then next page, my lords. Various conditions are there. Next page, my lords, your lordships get it, Form 3, my lords. That is for license for betting on horse race held on the race course. Form 2, what is important in Form 2, my lords, I may be permitted to read that. Form 2, the license shall keep, the licensee shall keep and maintain correct records. This is important. Form 2, my lords, license for horse racing on race course. Lordship may kindly note Roman 1. Licensee shall keep and maintain correct accounts of the receipt, payments, number of persons employed by the licensee, shall allow officers authorized by the government in that behalf to examine any of the accounts, books, records maintained by it. The licensee shall also furnish such returns so and so, so and so. Then Roman 4, my lords, in the next page. The licensee is authorized to grant permits to bookmakers not exceeding dash, subject to the following condition. 4, my lord. Licensee is authorized to grant permits to the bookmakers not exceeding dash, subject to the following condition. 4C, the bookmaker shall maintain correct accounts of his receipts and payments and shall furnish to the licensee daily statements of bets received, amounts paid and amount payable. Clause 5, licensee shall furnish to the government and the district magistrate annual return. Rule 6, again, my lord, is the obligation of the licensee. Rule 10, my lord, speaks about the licensee shall, in the month of April, during the currency of the licensee, furnish to the government district magistrate a report showing the particulars of races run, number of horses which participated in each race, rates reserved by Indian breed horses, stake of each race, names, nationality of jockeys, bookmakers, total collection on account, entrance fee, total collection of totalizers, betting tax realized, and such other matters which the information may be called for. This is the scope and ambit, my lord. So therefore, my lord, the obligation of the licensee is also very clear. And Form 3 is, my lord, just below 10. Is regarding license for betting on a horse race held on some race courses. What is happening, my lords, all these years, my lords, they were only getting permission under Form 3. There were no horse race license at all. Only betting license was there. For the first time, my lords, when they filed an application, my lords, we brought it to the notice that you have to file 2 forms. That is form under 1A.
So earlier they were holding license.
Only for betting, my lords.
Which is that license, date of license?
That late date of license, my lords. Latest is dated 31/3/2024. That is annexure, my lords. Page 244, my lords. Volume 2.
That license was for up to which period?
Please, my lords.
That license was for how many months?
Well, a month for month to month, my lords. The days, my lords, not months to months, days, my lords.
Particular days when we conduct the race.
Because they'll give the schedule of the race.
It was for what period?
No, the license which my learned friend is referring to was for particular days, 9/3, 15/3 and 16/3. Page 349.
9/3, 15/3 and
16/3. Not, can I just explain not how this methodology was? Not the.
No,
the
this license was the specific date.
Specific dates.
We apply only with.
We apply for those dates.
Because
For
there
example,
are you can conduct the horse racing and.
there are 2 types of race licenses now. When horses are actually running in Bangalore, it is called an on-course race. When horses are not running in Bangalore, they're running in different racing centers in the country, then no racing is held in Bangalore course, but we have to take a license for an off-course betting in Bangalore. That's how it works. So for the whole year, entire schedule is given. And we give the entire schedule of all the race courses in the country, and every just before the commencement of the season, we apply to them for the next month, 2 months like that.
So license which is given is for particular date.
Please.
The license which was rejected or the order which was rejected, 6/6/24.
Please, ma'am. Yes.
They had applied for which date?
They applied till various days till the month of August, madam. That your lordship, till August they had applied, madam.
From August.
Till August.
For entire period.
Yes.
From 21/3/2024 onwards, we had submit.
It's a summer season.
Not this.
What is that? What is the tomorrow's event is so important that is well tomorrow only.
Not this entire racing season, my lord, for 4 months now or 3 months, everything is shut down. Now, my lord, there are about a large number of horse owners. There are 800 horses which have come.
People have bring all horses here and now pressurize.
Not pressurized, my lord. From April on, from March.
We are asking that what is that significant? What is that sacrosanctness of tomorrow's day?
My lord, I would put it this way, my lord. If the race is held tomorrow, government will only stand to.
The day after tomorrow, next week after hearing completed, then what?
No, my lord, what I'm submitting is this, my lord. After all, balance of convenience has to be seen. The learned judge has seen it. Learned judge, my lord, finds that the reasons given are completely, my lord, illegal. And learned judge therefore says, what is the harm? Because there are racehorse owners, there are jockeys, there are 20,000 people who are dependent on this. From March onwards, my lord, not one day races have taken place. They kept quiet. They did not take a decision. We moved this honorable court. We gave 3 representations to the honorable chief minister and also to the chief secretary. They are unmoved. After we moved the writ petition before this honorable court, my lord, a direction was given that they must consider it. Then they hear and they give a reason. My lord, if my learned friend finishes, I'll point out, my lord, how perverse that reasoning is. They say that there's some raid that happened in January, February, March, they gave us licenses. They file a charge sheet in May. And thereafter, my lord, they say because of that raid, we are not giving you license. That's the reason given in the order.
Because of?
The raid. The raid, my lord, they conducted a search. And in the search, my lord, they found cash which is part of the business. and done by the bookmakers in the club, not by us. And that is the only reason which they give to say bookmakers are doing illegal things. So we submitted before the learned judge that we don't want bookmakers. We will not give them license. Let them not operate. Learned judge also says the government can monitor it. We have no objection, my lord. They can send whoever they want to monitor the racing activity. And there are two types. That happens, my lord. One is through a bookmaker who is licensed by us. The other one is by the club itself. It is called totalizator. In the charge sheet, my lord, they say that they went into the totalizator in complete detail. It is run absolutely transparently. There is no problem. That's what the charge sheet says. Now, my lord, if they say that some bookmaker has done something illegal in the premises where he is supposed to carry on activity, I am not responsible for it. How can they visit the consequences of some bookmakers' so-called illegal activity upon the club and the large number of owners, large number of trainers, jockeys, employees? There's a vast array of people, my lord. They've all been sitting idle, my lord, from the month of March now. And for no reason.
So another way of looking at it is, my lords, 2 days race, your lordships can hear. They are monitoring. It is, my lord, they have now said, we have said no bookies. They have said no bookies. If your lordships here, they can know in 2 days nothing is going to happen. 200 horses will race in this. We have given a schedule out of 800. It's not that all 800 start running, but they are trained.
No, that is not 800 or 200. What
No,
is
800 horses station, but not 800 take part in one race. So,
the schedule is there.
If 2 days, let us see. If they feel there is still something murky, they can always monitor.
All over India, my lord. This race schedule
after August, it stops here. They go to other circuits.
200 horses are scheduled to run for the next 2 days. You also may see the racing calendar published.
They can monitor for 2 days if anything happens.
After the interim order, that is on Tuesday.
Yes.
I have to fix it.
So you are apprehending some malpractice.
Yes, ma'am. There is.
Not the horse owners.
If they finish before the single judge also, they did not permit us to argue. Here also, when arguing, let me complete. They're like the horses, they're running, man.
No, in response to what he says, I just wanted to say this. It's a case of horse racing. It's not a case of horse trading. The government may not be so much perturbed. Racing will take place. Racing is generating revenue for the state government.
It will take place or not.
It's not a case of horse trading. Let the government may not be perturbed so much for racing. Milords, their only grievance is this, Milords.
You are in favor or against?
Milords, I am in favor of, Milords, all of us are in favor of racing. Government also doesn't say that it is not in favor of racing. Milords, I understand the concern of the government. The government says we are in favor of the racing, but let me complete. But what the government says is that when we conducted a raid, we found that instead of 100 crores being accounted for the purpose of collection of the GST, what they are accounting is only about 35 crores out of 100 crores. Not if this is essentially traceable to the bookmakers. What they said is when we conducted the raid, we found that the bookmakers had involved in some kind of malpractices, as a result of which some money is going beyond the accounting stream. They never said that horse racing is bad. I don't know whether the statement is being made today, but till now they have not made the statement that there should be no racing. Racing is bad. This is never the contention which is raised by the state government, and rightly so. Their only concern is that there is some pilferage of the taxation because something else is happening with the bookmakers. So far as the bookmakers are concerned, bookmakers comes into existence under a statute called as the Betting Act. The bookmakers are under the Betting Act. Now, so far as these bookmakers are concerned, once the bookmakers are licensed by us, which is authorized under the Racing Act, they are required to report to us that this is the total collections, and we are required to submit on a monthly basis the reports to the Deputy Commissioner. Now, what has happened is the Betting Act is repealed by virtue of the GST Act. Section 173 of the GST Act has repealed the Betting Act. Now, so far as the bookmakers are concerned, they become merely assessors under the provisions of the Karnataka GST Act. If at all anything has happened with reference to these bookmakers, the arms of law under the GST Act is so wide and strong that they can catch hold of anything, trace anything, and then get back the money. That is the extent to which the powers are now vested under the KGST Act. So, my lords, if the racing is, I'm sorry, my lords,
Before you continue raising arguments,
lordships.
may we ask, are we proceeding finally or for interim? What do you suggest?
Interim order is under challenge.
My lord, they have challenged the interim order, my lord.
Interim
My
order.
submission is this, my lord. If your
So it is
lordship-
either to continue or not to.
Only for
next
2
2
days.
days, my lord. My submission is next 2-3 days, my lord.
Police commissioner is one of the, on the board.
Let me argue the matter.
Finance commissioner and police commissioner both are sitting on our board, nominated by them.
To oversee.
The
They are
chairman, my lord, of this company, this race club, is appointed on the suggestion of the police commissioner and the finance commissioner in a board meeting. That is taken note of by the learned judge. All bandobast and police's protection is given by the state. And the act, my lord, provides they can place anybody in the premises of the club. If their apprehension is about betting, my lord, that some illegal things are happening, we have nothing to do with it. They can easily monitor it. I have no problem. And I've said I won't license anybody. Let racing go on, my lord, because large number of people are involved. My lord. They're veterinarians. There are.
Yeah, make one submission, please. My submissions are 2,000 lots, trainers are involved. Now, how does my money come? And my salaries, lots, all these salaries, lots of these 2,000. From the racing, please, lots, whatever is the stake money, 30% of it will only flow to us. If racing activity is stopped, please, lots, we will not get our salaries. Life and livelihood, please, lots, is very important. Now, just because 2 lots bookies have done some lots issues somewhere, the life and livelihood of 2,000 lots, families cannot be wiped out. Is my respectful submission. And one another submission, lots, the criminal proceedings, what the Advocate General is pointing out, that was initiated, please, lots, on January 16th, please, lots, 2024. Up to April, please, lots, they have lots renewed the license. So today to say that because of the criminal proceedings, we will not want to lots renewal license is too far-fetched, please.
I think they have completed the argument.
Yes, completed. Since
All of them are
therefore only we
completed.
have asked you to
Please.
start. Otherwise, yes.
This turf club, just to give a back, this turf club, my lords, I've got 350 members, my lords. The procedure, unlike other clubs, is not by seniority where they file an application, they become members. If a vacancy arises in these 350 clubs, my lords, they vote among themselves. Virtually, my lord, there are only 150 members who control the 78 acres of land, who conduct this racing. Actually, there are only 150 members comprising of their brothers, sisters, brother-in-law, son-in-law, my lords. So, my lords, these 150 members want to control this club. This is all all these horse racers, trainers. That's not the issue over here, my lords. And the people who bet over here, my lords, are auto rickshaw drivers, taxi drivers. It's the poor man's money which is being done. So therefore, my lords, there's no great urgency. It's not that they're running a hospital which is being closed down. My lords, what is going to happen is poor people are going to save their money. So insofar as balance of convenience and irreparable injury is concerned. Just I'll quickly run through the
Bookmakers are necessarily attached with the event.
What has happened under the rules which I pointed out, my lords, the license, we give the license, horse racing license and the betting license to them. Under this, they can further license to bookmakers, who the club. They have licensed 26 people, my lords.
So club can give further
License to these bookmakers.
Pursuant to your license.
Pursuant to our license.
Where is that provision?
That I'll just, section 4.4, my lords. I'll just point out, my lords.
Purpose of interim order, we have said we will not give any license to any bookmaker. For the purpose of interim order, we made a submission before the learned judge that the club will not issue any license to any bookmaker.
But that has been permitted by the single judge, my lords.
Even now I'll undertake.
No, that is not.
I will not give any bookmaker's license.
My submission is, even if my order was set aside, permission by the single judge to run horse race could not have been done. Even if I were in the worst scenario, if the impugned order is set aside, it could have been remanded back to the government to reconsider the same.
Now, this bookmaker's role can be segregated with the event.
No, my lords, it can't be, my lords. It can't be, my lords. It is not the. It is not our case. It is only because bookmakers, who are involved is the chairman, secretary, and who the other person, the manager are involved in.
Your apprehension is that without license from you also bookmaker can operate.
Please, my lord. What happens is, my lords, the chairman is also an accused in this matter.
Just to explain, my lord,
inside bookmakers will exploit the event.
Please,
irrespective of license. That is
please,
what
My lord, in the precincts of the club, my lord, the license which they give us permits us to license a bookmaker. A bookmaker is one, my lord, who accepts books. They are called bookies.
Without license, you go on betting, then what?
It can't happen.
No, that is illegal, my lord. On the streets, they're doing it. Today, my lord, on the streets, they're doing it. So inside our premises, if we don't give a license to some bookmaker, the bookmaker cannot operate in my premises. That can be absolutely ensured. There's no
He'll open it
difficulty.
in some other
The
place
police
and
are there.
He'll open in some other place, the same horse race will be going on, the betting will be going on over there.
No, that is illegal, my lord. If suppose, my lord, it's like this. If somebody is doing illegal activity outside my premises, if the bookmakers are standing on a road or sitting in some place and do illegal things, they can take action against them. Why punish me, my lord? I am running races, which is a game of sport. It's a game of skill. Supreme Court has said that.
Lord, similar thing happened with even IPL. When the cricket matches were going inside the stadiums, the CCP itself conducted raids and said that there are people who are acting as bookies for the cricket matches which are happening inside the stadiums. I'm so very happy that the state government was very considerate that it did not ban the IPL matches. They did not ban the IPL matches, but the same thing happened. They also caught the bookies there. IPL, I have the list of the. I have the list of all the
activities will go on. We can't do anything about it.
It is not so, my lords. The government, do they want to come before the court and say they are helpless? That they don't have a mechanism to ensure that these illegal activities are curbed and that they are helpless? Lords, now bookmakers can clearly be bifurcated.
Would you permit us to
Sorry,
listen to your argument systematically?
Please, my lords.
Or you go on interrupting?
Apologies, my lords.
Every now and then, without we asking. Yes, Mr. Advocate. This is not the way of standing up like anything and arguing like anything. Answering every sentence and every word of the petitioner.
So I'll just quickly run through the list of dates.
No unscientific hearing, Mr. Otherwise, we'll not be able to finish the matter.
I stand corrected, my lords.
It will go on and go on like anything, yes. So now you also go to the point.
I'll go directly to the point, my lords.
Yes.
Your Lordship may kindly see FIR was registered on 12th January 2024, my lords.
Yes.
On serial number 3, 30th April, my lords. Criminal petition was filed, but 26 bookmakers came to be dismissed.
Now, the bookmakers are your licenses?
No, their licenses.
Their license.
Their licenses. We license.
All right.
They are our licensee. They in further license to these 26 bookmakers. On 15/5/2024, CCP filed a preliminary charge sheet of against 91 accused for offenses punishable under 406, 409, 120B, red with so and so. Accused number 89, Vijay Narasimhan, is a betting ring manager of the BTC. Kiran MK is the CEO and secretary. Accused number 91, Arvind Raghavan, chairman. So therefore, my lords, their argument that they are not involved is not correct, my lord. Their accused number, BTC chairman, secretary, and the betting manager are accused number 89, 90, 91. They have colluded with the other accused, my lords, to carry on this illegal activity, my lords, in the premises of BTC, my lords. And the loss, I'll come to that later, my lords. Then I've just produced the charge sheet is next page, my lords.
Who are the persons who are named?
That is, Your Lordship, 89th accused, my lords, is Vijay Narasimhan, betting ring manager, who is the employee of the Bangalore Turf Club.
Then this second number 90.
Accused number 90 is Kiran, is the CEO and secretary of the Turf Club.
CEO and secretary.
Of the Turf Club, my lords. And accused number 91 is Arvind Raghavan, who is the chairman, who is the main person in charge of the Turf Club. I produced the charge sheet, volume 4, page.
Record you have produced before learning single.
Yes, yes. And I've given the page number and volume number here, my lords, where the name of forthcoming.
And how many petitions were there? 5.
Yes, I am the club, my lord. There are trainers have filed. Totally, my lord, there were
5 petitions.
5 petitions.
One is by the club, one is
and
by.
You are representing.
I am
all,
the club, my lord.
Mr. Counsel, you are appearing whom, Mr.
Lords, I am appearing for the trainers. Trainers.
They were respondents or petitioners?
Lords,
Lords,
there
petition.
are petitioners only, my lord. There are 5 petitioners.
And you, mister? He is
The Karnataka Trainers Association.
one of the petitioners.
Yes. And there's one Racehorse Owners Association.
Yes.
So my, insofar as this 4 petitions, except the BTC, my lord, rest of the 4 petitions is not maintainable, my lords, for the simple reason that, my lord, they have not filed an application for license. Then, if I may request, my lord, 31st May 2024, meeting between the Department of Finance, BTC officials and stakeholders. Proceedings of the meeting, volume 3, so it's a fresh application for grant was filed by them, my lords. My lords got it, my lords. Fresh serial number 5. Because what had happened, my lords, before, I'll just, can I make an explanation here, my lord? What they had done is they had filed only application for betting license. We pointed out that you had only filed application for betting license.
Please give the date of earlier license.
Early license date, my lord, is that
31/3/24. It can't be.
please, my lord. The earlier date of license, I'll just give it in a moment, my lord. Your Lordship may kindly see is in the, I'll just point out, my lord, their applications are dated. Their application dated 21st March 2024 as per their prayer in page 127. 21st March 2024 and 18th April 2024. 21st March 2024, 18th. No, I'll come.
Application.
Application, I'll come to the license also, my lord. They had filed 3 applications dated 21st March 2024.
They applied for license
Yes, my lord.
because there is no license in existence.
Correct, my lord.
Now, which was the license which expired?
The last date of the license which expired, 31? 31/3/24 annex.
It can't be 31/3/24.
No, because they, before the expiry, they filed that application.
No, because they are saying that the license was granted
Subject
for
to correction.
9/3.
Can I give the dates, my lord? I have the dates of the licenses, my lord.
Last of
The license, my lord, at page 325, there's a license given, my lord, on 1/3/24. That was for 7 days.
Correct.
Of course,
9/3, 15/3 and 16.
yes. Then, my lord, on
266.
5/3/24,
266.
5/3/24, they gave a license, my lord, for off-course betting at Delhi.
So that license was specific for
Specific dates. My lord, we give application saying off-course meeting is held, on-course meeting, so they consider and give it for those 4 or 5 days at a time.
So one which was rejected on 6/6/24.
Yes, my lord, 6,
Was pursuant to which application?
that was, my lord, pursuant to April, my lord, from April to August. For the period April to August, we had filed number of applications, my lord. They are all, my lord, exhibited from 21/3/24 onwards.
So you wanted the license from April to August.
From end of March till end of August. We gave the fixture dates.
You gave dates.
Yeah, we gave specific dates and we
for
made
that-
individual applications.
For license.
Yes.
For those days.
For those dates.
And all those are.
All of
rejected
them
on-
have been rejected now by the impugned order, my lord, on 6/6/24.
So that details kindly
Yes.
make available. made
My lord,
available.
that is at page 40.
Write down and give the.
Yes.
My lord, page 41 of the prayer talks about 3 applications, my lord.
Because you are saying that there was a FIR thereafter. Or pursuant to which?
FIR was earlier. No?
Earlier?
FIR was 12th January 24. No? 12th January 24 was FIR.
FIR was earlier.
Yes.
Your Lordship may kindly see the serial number 1 in my list of dates, my lords, is the FIR, my lords.
Yes.
Serial number 4 is the charge sheet, my lords. 15/5/2024. The application dated is 21st March. 25, page 41 of the writ petition, my lords, for 21st March 2024, 18/4/2024, and 2nd May 2024.
Now it is clear. Now. please proceed.
These are the 3 dates, their application. Last of the date of license granted was, my lords, on 16th March 2024. That is at page, starting at page number 265. Dated 7th March 2024. It was given for 3 days, my lords, for 9th March, 15th March, and 16th March. Annexure A, page 349, volume number 2. My lords got it, my lords, volume number 2, page 349. Huh? Yeah, right, 7th. Dated 7/3, my lords got it at page 349, my lords. 349. Court officer.
This is for the actual races, on course race at Bangalore. Volume 2, page 349. It's in Kannada, my lord. The dates are given. Your lordships will also get the dates in page 266 in English.
What is that page number?
At 266, your lordships will get the dates in English. Dates they gave was 9/3, 15/3, and 16/3 for 3 days of racing.
If I may request, my lords, just kindly page 414 for a moment, my lords. 416, my lords. 414, that is volume 2. Volume 2, my lords, same volume for a moment, my lords. My lords got it, my lords. Volume 2, court officer.
Now you are stating that on 6/6/24, the license was rejected by the Finance Department and Home Department after consulting the authorities such as Police Department, GST, etc. Now
Please.
that consultation is in record.
There are documents, my lords, I can place that, my lords.
Any document which shows that the
impugned order itself is,
particular kind of opinion is given by the Police Department or GST Department.
your lordship may see the charge.
So what is the basis of your statement that consultation was undertaken?
Because we have.
Something must be there, you are a government.
It is there, my lord. I'll place it before your lordship. For 414 may be kindly seen, my lord. Page 414, your lordships will get it, racing fixtures for the month of June 2024. Your lordships will get it on the right hand side, the centers, my lords. The tabulation is there, June. Page 415 is for the month of July. Page 416 is for the month of August, my lords. What we have considered, my lord, because further investigation is going on, my lords. If we have not said that we are permanently closing it down. Charge sheet is filed in the month of May, my lords. Charge sheet is filed on 15/5. And accused number 89, 90, 91 are also part of the BTC, my lords. And totally there are 89, 87 other, 88 other accused, my lords, who are Benamidars, bookmakers, unauthorized persons who have come in the thing whom the BTC has permitted and not taken any action against them, my lords. Now they are saying that it all takes place within the premises. Now they are saying being a licensee whom we have given license, I don't know about any of these people, what they've done, you punish them, keep them out. But let me carry on what I want to do. That, my lord, being and they further, and they have issued the license to those 26 people. They can put their hands up and say, yes, they are done illegally. What am I supposed to do? Admittedly, my lords, they have done something. And my lords, I'll be able to point out in 3 races, a cash of 3.5 crores has been recovered. Not even 1 rupee is accounted for as on the date of raid. That means, my lords, your lordship may kindly see how it is being done. Show the photographs.
Same thing is on record. No photograph on record.
It was given before the single judge. The photo, uncolored copy, Xerox copy is part of the record. I'll show the which page and which.
What is this?
My lords, one more quote of it. My lords, what they do is, my lords, so that it is not legally done, they take this receipt, my lords. Your lordship may kindly see.
This is what you're showing.
Please, my lords. This is how they give a chit, my lord. There's not nothing to give a copy to them. These are only color photos which are part of annexure volume 7, page number 1947. Is this a color copy which was placed before the single judge? That is at page 1947. What they do, my lords? There's no invoice, no betting card, nothing, my lords. So, your lordship may kindly see the photograph below, my lords. All these are standing on the floor. All these receipts, my lords. And the chairman is also seen in the photographs over here.
The chairman photo
My lords, what is being done, my lords? In fact, give the chart. How much
police officers had cup of coffee. They took a photo. They say, please file it. We'll explain that. My learned friend says there's a photo of the chairman. It's not on record to the best of my recollection. If it is there, let it be produced and we'll, my lord, appropriately meet it. What happened?
In fact, the chairman filed a quashing petition under 482, my lords. This court did not grant a stay. In fact, made a submission that we will not arrest him, but directed him to cooperate with the investigation.
You stated here.
I've stated that, yeah, my lord. So this, my lord, therefore, my lord, one is, my lords, what is happening at 86 Benami transaction, non-deposit of money in cash, non-raising invoice as required, permitting non-bookmakers in their punters to betting in the premises. Then, my lord, 1999, what had happened, my lords? 2019, there was the allegation of drugging the horse, my lord. There are 14 accused in the 2019 charge sheet has been filed, serial number 6. Those 14 accused in 2019, they are also being permitted as continued as bookmakers, my lords. No action has been taken by them till we filed a charge sheet against them. Permitting 14 accused in crime number 175 of 2019. Your lordship may kindly turn to page 3, my lords. Page 3 on top, Roman 6, my lords. Roman 6.
Yes,
permitting 14 accused in crime number 178 to continue carrying on betting activity even now, when amounts to violation of the betting license granted to petitioner, and they are solely responsible for the same.
Who are these 14 accused?
14 accused, my lords. I'll give the accused are.
They are also, they're outsiders.
They are bookmakers, my lords. Bookmakers.
But not the employees.
Bookies. No, not the employees. They are bookies, that meaning to say that the license given by the BTC, my lords. The BTC has given license to these people. So, okay, we'll come to that. Next, my lords, approximate loss is around 296 crores, my lords. I'll just explain 296 crores in a year. An amount, next Roman 8, an amount to the tune of rupees 3 crores 45 lakh 74,000 was seized on the date of raid as outcome of 4 races. The fact that BTC allowed yellow betting cards, pencil sheets were allowed to be used in the premises and allowed punters to collect cash, people without issuing proper invoices or amounts collected. I've just pointed out where the witness statement discloses that investigation also discloses that during 28% of the tax was collected and there is no paper on record to show that the actual amounts were collected on behalf of the state. There is a stark contrast between the tax paid history and the amount found on the date of the raid. The betting cards did not include tax invoices and GST. One of the yellow card which I showed, it doesn't include all that. Further investigation is pending concerning the exact role played by the BTC and its official in relation to criminal conspiracy breach of trust. The investigation also requires to trace money trail in connection with the case. Failure of the chairman of the BTC and other managing committee members to regulate curb illegal activities. What original petition was only to consider representation, my lord. After it was rejected, they amended the petition. Then a 48-page interim order has been passed, my lord. Your lordship may kindly see the auditor's report, my lord, at volume 4. What officer? Volume 4, could you? Page number 1149. Volume 4, page 1149.
So what is this 1149?
Manoj, this is the auditor's report, which is part of the investigation, Manoj, which was taken into consideration at the time of passing the impugned order. Manoj. The lordships will get it starting at page 1145. Manoj. 1145. Can I request, Manoj? 1145.
One 1145.
45, my lord.
Yes.
Auditor's report to the Assistant Commissioner of Police, Investigating Officer, Special Inquiry, my lord, that your lordships will get on page 115, 1145.
These all things were before Lanachal.
Yeah, everything was before. And my lord, this is part of the impugned order. Impugned order contains all the details, material, charge sheet, all this report it contains, my lord. Impugned order runs to nearly 600 pages, my lord. It contains every investigation report, witness statement, all this report, everything has been gone into, man.
That 6624 order.
Please, my lord. All the annexures, the order is short, but it relies upon all these annexures. It's a 600-page order, man. Your lordship may kindly turn to page 1149. My lord, in the worst scenario, if I may put it, my lord, question of issuing a positive direction to run on the same conditions which was being run prior to the charge sheet being filed, and not to interfere with the carrying on their business, carrying on horse racing, my lord, it could not have been a final order also. In fact, my lord, the learned single judge says whatever is submitted by the Advocate General will be considered only in the final hearing. Now it will not be considered. Para 22 clearly say that we'll consider all this regarding maintainability of the writ petition, judicial review, all and all these allegations. All this will be considered final. But 48-page interim order, all contention noted by the BTC, my lord. I'll point out to that, my lord. I mean, at least the judgments referred to, our points argued, none of them have been considered.
No, it is all long judgment. Everything is recorded.
Please,
judgment is elaborate enough.
No, it could have been a final order. It's actually interim order. It could have converted as final judgment. Therefore,
we also ask whether you are Today we are on the interim aspect.
Only on the interim, only on the interim. Page 1149. my lords. Can I request page 1149, my lords?
Yes, 114.
Right at the heading is called estimation, my lords. 1149 estimation. On the right hand side, my lords.
Now you narrated all these things
Sure.
in your list of events.
Whatever I referred to is part of the compilation. I've given the page
No,
number.
that is right, but on you again serial number 8, 6624. 1, 2, 3, 4, 5, 6, 7, 8, 9,
Please.
10, 11, up to 15.
Please.
All these facts are part of the impugned order itself,
Yes, 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 yes.
part of the record of the impugned.
Please.
State has incurred huge loss, GST not collected,
Please,
non-AMI
everything.
transaction, non-deposit of collection money, non-raising of invoice. So this is all
I've referred, please, no, part of the record, part of the impugned order itself.
recorded by the who passed the impugned order?
Insofar as horse racing by the Home Department, Home Ministry. Insofar as the betting is the Finance Department.
So two separate orders.
Two separate orders.
Even date.
Of even date. my lords.
Now, where are those orders? Now, first complete your 1149.
I'll just complete that, my lord, then I'll go to the impugned order. my lord. Just I'll take 2 minutes on this. Page 1149, estimation, my lords. Based on the method estimation adopted by underlining assumption, in our opinion, the estimated betting amount collected by bookmakers at BTC during the period 1st April 2023 to 31st March 2024 is 192 crores 66 lakhs 79,000. So it is 192 crores, my lords. What according to the estimation they have come about how they have calculated that. Cash seized by the police from bookmakers on 12th January 2024 was 3 crores 43 lakhs 42,000. Total number of races held for 23-24 is 1,805. Total number of days in 23-24 is 252 races held both on course and off course. Number of races for which bet amount was collected 5. Bet amount collected is 68 lakhs. The average bet amount collected per race is 68 lakhs 68,408. Total number of races scheduled to be held on 12th January 2024 8. Estimated bet amount collected by bookmakers on 12th January 2024 is 5 crores 49 lakhs 47,264. Number of persons who have visited BTC on 12th January 2024 was 3,728. 1 day.
This figures amounts to some illegality.
Yes, what they do is, my lords, they,
That's a private auditor.
I'll explain.
So we are
If they are able to explain better, let them explain, my lord. Otherwise, because the reason is this.
No.
What they
You are saying that this 68 lakhs 68,408.
Please,
The average bet amount collected per race.
Please,
Is it an illegality? Irregularity?
No,
malpractice?
not declaring is an illegality. Taking it and
Not declared.
Not declared. That's the whole point. The whole case is they have 5 races that
They have not declared.
that is the point, my lord. I'm not. If they declare, my lords, the whole issue is not there at all. The day we raid it, my lords,
It is required to be declared by whom?
by the licensee, my lords, by the licensee, Bangalore Turf Club.
It's not seized from us.
Their argument is, my lords, it is not seized from us, it is seized from our licensee. I have no control over him, even though it takes place in the BTC. I have no control over him. So why are you asking me? I'll do what I want. I'll remove them. Therefore, my lords, per day visit is as on actual visit on 12th January 2024 was 3,728. Cash recovered
back to the punter. End of that race, he will come back. If his horse has won, he says 1 for 2 means he'll take 200 rupees and go. This is how the business runs. They go to the club on a particular day. They create a lot of drama and they count all the cash. This entire business is cash. So the bookies who are there, they carry cash because first 2 races, if he has accepted bets worth 10 lakhs, he might have paid out 20 lakhs because everything is paid out then. And he has to maintain books and he has to pay 28% tax to GST department. Now, if GST department finds that something is not done properly, they may as well investigate. But many times when a raid is conducted by income tax authorities, if they go to a premises and they find cash, if the businessman says, yes, sir, this is my business, this is cash, I'm going to put it in my account. You can take it, I have no problem. Now, on that basis, they give this reference to an auditor and he makes some hocus pocus calculation. And the interesting thing is, none of this is put to me. But I don't understand this kind of a adjudication by them. I am a licensee from 150 years the club has been running, racing has not stopped. 3 times in the past, they tried to stop it. Question, my lord, we made an application and if they say no, but these are matters, my lord, which were not within my knowledge, within anybody's knowledge. They're going to, my lord, use something. I made an application. They conducted a raid on 12th January. If they had only put it to me, look here, 12th January, some cash was discovered in the bookies. What do you have to say? The explanation would have been given.
Please. Your Worship may kindly turn to impugn order. Main order. Volume 3, my lords, is the impugned order passed. Not the learned single judge's order, my lords, or my order. Volume 3, my lords. Yeah, I'll just point out the Volume 3, page 453, starting 453. Oh, sorry, I stand corrected. 543. I'm sorry. Your Lordship got it, my lord. Your Lordship may kindly see the references. That is important, my lords. References. Copy of the letter dated 31st May of the BTC, so and so to the Home Department. Copy of the interim order, my lord. Then copy of the letters dated 21st March, 18th April, 2nd May. These are the applications filed by the petitioner. Serial number 3 is the applications filed. Copy of the proceedings of the meeting. We heard them on 31st May 2024, my lord. Copy of the letter dated 31st March, Secretary, Finance Department. Copy of the letter dated 31st May of BTC to Additional Secretary to the Honorable Chief Minister, Additional Chief Secretary Department. Letter dated 5/6 of the Additional Police Commissioner, Crime City, containing following documents. Complaint dated 12th January 2024. FIR in crime number 9 of 2024. Charge sheet dated 5/5/2024. Auditor's report dated 4/5/2024. Again, 14/5/2024, both 25. Copy of the statement recorded under section 161 of the CRPC of the Deputy Commissioner GST. Copy of the chairman, copy of the statement of the chairman BTC recorded on 161 of CRPC, my lords. I'll skip the preamble, my lords. 1, 2, 3, 4. Then your Lordship may kindly turn to 546, my lords. Upon perusal of the document at references 7 to 76, it is forthcoming that on 12th January 2024, FIR has been filed, so and so. Illegal activities on the same day. In pursuant to the complaint, a raid was conducted by CCB on BTC at 3:45. The raid 26 bookmaker stall in betting ring of BTC, including total counters of Turf Club, cash to the tune of so-and-so, 56 mobiles and accessories such as betting cards, pencil sheets were seized by the CCB in the said raid. On 15/5/2024, CCB filed a charge sheet again 91 accused for offense punishable under so-and-so, so-and-so, so-and-so. My lord, what is important, the list of accused includes 2 members of managing committee, 90 and 91, the betting ring manager, 89, 27 bookmakers, 5 Benami bookmakers, 7 unauthorized person, and employee of the club bar book stall. That the reading of the charge sheet would indicate that the accused number 84 to 88 were operating bookmaker stall, accused number 2 to then, my lord, these are the various reasons, my lord. They've gone in detail, my lord. I'll skip, my lord. Please, my lord. Then, my lord, what they do is, my lord, your lordship, horse racing, in this is horse racing, my lord. Betting is at volume number 5, my lord. It's by and large one and the same, my lord. At volume number 5, page number 1166. Volume number 5. Page number 116. And my lord, one other thing, my lord, it is not that they have stopped permanently, my lord. The question is, we have only for June to August, which application is pending, my lord. Further investigation is pending. That has been not considered, not granted. Page 551 for a moment, my lord. 551. That further investigation is pending concerning the exact role played by the BTC and its officials in relation to 120B, criminal breach, criminal conspiracy, criminal breach of trust, cheating. Further investigating also is required to trace the money. When this is going on, they cannot go on carrying on their activities as if nothing has happened. Page 551 N, my lords. 551 N. Further investigation is pending concerning the exact role played by the BTC and its official in relation to criminal breach of trust, criminal conspiracy, criminal breach, and cheating. One other thing is what sorted to, my lord, argument of prejudice. We have nothing against them, my lord. Huge amount of money is involved. We need to go to the root of the matter. Let the investigation final charge sheet be filed, my lord. Truth will come out. Then we'll see how to put the system back in place, my lord, and then run it. We are not against them doing horse activity. As my learned friend said, 150 years is going on. Then, my lord, the other impugned order by the finance department betting is almost similar, my lord. I'll not go into that, my lord. The only other question is the order of the learned single judge, my lord. So I'll just point out the order of the learned single judge, my lord. That is at volume number 1. The finance department is volume number 5. Please, my lord. I'll just point out that.
Page 1166.
Please, my lord. Both orders and challenge, my lord. Please.
1168, para 6A, my lord, is the only reason given. 1168.
No, no, let me 1166, my lord. I'll point out, my lord. With the references also, my lord. Your lordship, what is important is, my lord, all the details basically to say, my lord, before passing the impugned order, complaint from the GST, Home Department, Finance Department, all that material corrected, my lord. Then page 1168, my lord. Para 5, para 6, that on perusal of the documents that refers 10 to 16, it is forthcoming that the Home Department while order dated rejected the application of BTC as submitted under rules also for conduct of horse racing license and such the absence of the license to horse racing, license of conducting betting of horse racing cannot be granted. As detailed, the order of the Home Depart contains Karnataka so and so read along with the charge sheet clearly indicates the BTSC has prima facie failed to supervise, monitor the conditions of license and maintain the records and books of accounts relating to betting transaction and other allied activities by the bookmakers and has failed to ensure the bookmakers maintain tax invoices, register book of accounts, so and so, so and so. Then, my lord, it's the same thing, my lord, as was pointed out. Subsequently, this application was also rejected, my lord. Into my copy of the no. If Lordships will get at page, volume 1, page 38, my lords, of the learned single judge's order. Volume 1, page 38, is it correct? Page 43, my lords, paragraph 12. Is page 43, paragraph 12 is the submissions made by 12 and 13 is a submission made by the petitioners, my lords. Page 43 and 44. Please, my lord. Rule 4.4, my lord. Section 4. Yes, my lord. Your lordship may kindly, my lord. I'll please that please, my lord. Rule 5, my lord. Rule 5, my lord. Rule 5, my lord. The government rule 5, my lord. The government may call for report, my lord. Your lordship, holding the act, I think.
So race course license.
Rules. I'm sorry, my lord, my apologies. Yes, licensing rules, rule 5, my lord. Right at the bottom, my lord. Can I read that, rule 5, my lord? The government may call for a report from the authority as it thinks fit after such inquiry deemed fit, if satisfied the desirable granting license. this discussion that knowledge. No. I'll just point out that one. I'll just point out. With the word used in Rule 5, if satisfied, Manoj. If satisfied of the desirability of granting license. Rule 5 says, if satisfied of desirability of granting license. Section 8. Section 8, Manoj, say that granting and refusing of or cancellation of license conditions and so shall be with the discretion. I'm grateful to Manoj. Rule 8. Section 8, Manoj. Section 8 and Rule 5 also. Rule 5, what it says is, if satisfied, satisfaction is of the licensor. The volume 1, page 40, learned single judge order starts at page 38. The relevant portion is that para 12, which starts, Malot. Page 43. Internal, running page 43. Internal page 6, running page 43. Internal page 6, para 11. Having heard learned senior counsel for respective petitioner and learned advocate general for the respondent state and produced material. Para 12 and 13 and 14 is the contention of the petitioners, my lords. I'll skip that. Para 16, page 43, para 12, my lords. Page 43, para 11. Heard learned senior counsel, members, para 11. Volume 1, I think, court officer, volume 1 court is there.
Page 43.
43. Right on top, pagination. It's like this one. It's okay. Para 11 speaks about heard learned counsel for the respective petitioners, learned advocate for respondent. Para 12 and 13, 14 is the contentions of the petitioners, my lords. Para 15 and is the state's contention. Para 17, my lords, is the consideration, my lords. Para 16. I have given my anxious consideration to the rival submissions and produce a material on record. Your Lordship may kindly note from para 17 onwards, what till paragraph number, my lords. Paragraph number that is running page number, my lords, internal page 11, that is to page number 36, my lords, or all judgments cited by the petitioners. The reproduction of all the judgments cited by the petitioners, my lords. Each and every case is of the petitioners, my lords. That's my submission. Not then, my lords. Then page 74 is the reasoning given by the why the impugned order is bad, my lords. That is page 74, Roman 11. Right at the bottom, my lords. Page 74, Roman 11. It goes. Why the impugned order is bad? Then can I request, my lords, para 18, my lords, page number 81, page 81, my lords, the conclusion. It is necessary to state that I have arrived at a aforesaid finding. My lords got it, my lords. Page 81, para 18. It is necessary to state that I have arrived at a aforesaid finding based on prima facie scrutiny of material on record and upon consideration of rival contention for the purpose of interim prayers sought for by the petitioner. In this context, it is relevant to note that by virtue of the impugned or the entire racing and betting activities of the petitioner, which was hitherto being carried on continuously uninterpreted for decades, has now come to a complete standstill and grinding halt, thereby resulting in irreparable injury and hardship, not only to the petitioners, but also to race horses themselves, who are lying idly without any racing activity, which would cause ailments, disease, etc. to the race horses, which is sufficient to indicate the balance of convenience in favor of the petitioner. Malad, nobody has stopped them from running the horses, Malad. They can, next, Malad, para 19. It is also to note, since majority of the allegations contained in impugned orders are against the bookmakers, both licensed and unlicensed, petitioner BTC has undertaken to cancel all the bookmakers' license and not to grant any more license, which would be sufficient safeguard for further activities being carried on by the bookmakers in future also. These facts, circumstances obtaining in the instant case would unmistakably justify invoke. No, I understand. It's a practice. No. Was. Then I think that it will change from today, Malus. Malus, para 21, Malus. Just para 22, Malus. Your Lordship may kindly turn to para 22, page number 84. Insofar as judgments relied upon by the learned educator are concerned, the said judgments would have to be examined in detail at the time of final hearing. As such, it would be not necessary to deal with the same elaborately for the purpose of at the present of interim stage. So therefore, none of the contentions what was considered there, the judgments and the conditions not considered at all. Only one main reason is ailment to the horses. Insofar as only an application filed by BTC can be considered. The race owners, trainers, various people have no, writ petition is not maintainable. They have no local standard to file the writ petition at all, my lords. In fact, because then they have not filed any application, I need not consider their application. Their application is not considered. Rest of them, except for the BTC, only persons whose application is rejected can be considered. They are only consequential, my lords. So to say that their right should be considered, and their right has been considered vis-a-vis rest of the thing. Last submission, my lords.
The Trainers Association. Trainers Association. Trainers, horse trainers. Horse Trainers Association.
The owner of every horse, my lord, will have to engage.
No,
no, they are watching, my lords. bookmakers are watching as to what is happening.
Government is also.
I am for the jockeys. Jockeys.
The horse riders.
They are the horse riders, the jockeys. Yes.
Please, last, my lord, the learned single judge has stepped into the shoes of the Home Department and the Finance Department, my lords. And one finance granted, I mean, worst comes to the writ petition allowed also, my lord. I leave it that one. Therefore, I'm humbly pray interim order. I'm short, my apologies.
My lord, this case has a bit of a history, my lord. So if your lordship permits me, my lord, as quickly as I can, my lord, I will take your lordship through that. My lord, this land was given to us by the Maharaja's time during the British rule. It was first given to us, my lord, in 1915. And over a period of time, the land has been with us. And the lessee, the owner, my lord, its character changed. It was called the Racing Club, it was called. Riders Club, it was called. Later on, my lord, it's taken the shape today. It's a limited company under the Companies Act. It's a guarantee company. So, my lord, the land is vesting in us. Over a period of time, the government started asserting that this land belongs to us and we'll give you a lease. Yes, that's what I'm just coming to that. That's the point. Now, my lord, the government contended that this was a limited term lease and we have now brought it to an end. So you have to leave. You have to go. That was questioned in a division bench order, my lord, of this honorable court. There were a number of matters. This honorable court, my lord, came to the conclusion that the land did not belong to the club, but gave a direction that we should move out and gave a direction that this land must be kept as a vacant space. No construction to be done. It should be like an urban forest. Lordships might have seen, it's a huge extent, really 100 acres of land right in the heart of Bangalore. Like most of the big cities in the world, my lord, we have race courses in the heart of the city. In Bombay, we have Mahalakshmi. In Madras, we have Gendi. In Hyderabad, we have right in the heart of the city. Like that everywhere, my lord, it's been an old sport which is always located in the middle of the city. Fortunately, that's green space for us now, lung space for us now. Otherwise, it will become another concrete jungle there. That order was challenged before the Honorable Supreme Court. The Supreme Court, my lord, asked them, racing is such a big sport, you are earning money from it. You give a license and you take license fee. You allow betting and you take every bet, 100 rupee bet place, 23 or 28 rupees go to government. This is a big source of revenue. Every day a horse race is run, my lord, in India. In state government will earn approximately 1 crore rupees. Every day it runs from all the sources of revenue which it's going to get. Now, my lord, from April till now, they have lost 1 crore a day when they have stopped this by this action. Before the Honorable Supreme Court, their lordship said, why don't you settle, give them some other land? And discussions took place. Finally, government said, no, we are not agreeable. So the Honorable Supreme Court, my lord, made an interim order. Kindly turn to volume 1, page 276. At 277. Last para. Learned Advocate General submits that till the hearing, volume 1, my lord, page 277. Honorable Supreme Court order. Learned Advocate General praise time granted 2 weeks. Counsel liberty to mention after pleadings. Third paramount. Learned Advocate General submits that till the hearing of these matters is concluded, parties shall maintain status quo. This order, my lord, is passed on 7/9/2010. Subsequently, my lord, leave has been granted in this matter. Page 277. 277. Yeah, this is regarding the activity that is going on there, because the contention they took was lease is over, we can't give you license, you can't be permitted to run. You are a tenant, by holding over, you have to give it back. And there's an order of the Honorable High Court which says return it. So when this, absolutely, my lord, my first submission is that this order, my lord, prevents the government from taking any steps to ensure that the status quo which has prevailed in 2010, which is we are in possession, we are running races, racing activity is carried on. From 2010 till 2024, 4 attempts were made to prevent us from racing. Every time we came to this honorable court, every time we got relief. First, they said we're cancelling the excise license. There's a clubhouse which serves liquor. That was challenged. Then they granted it. Then, my lord, they said, oh, you're only some few people running this. We want to become members. So you give us membership. That was stalled. Then, my lord, third time, in similar manner as they did now, they did not consider license application. We came before this honorable court. Now, my lord, please peruse the order passed by Lordship Justice Bopan as a learned single judge. Same volume, second volume, 301. Page 301. I won't read all of the order. Again, argument. Lord, if your lordship doesn't mind, perusing the prayer, my lord, in the matter which is pending before the Honorable Supreme Court, because the status quo, my lord, at page 121 in volume 1, my lord. Sorry, I'm going back to volume 1. This is the prayer, my lord, the top of page 121. Page 121. About 5 lines from the top, it is put in parentheses, in inverted commas. This was the prayer. Issue, page 121, volume 1. (121), my lord, about 5-6 lines from the top. There's a reference to WP 30663. That is the one we had filed, club had filed, to issue a writ in the nature of mandamus or any other writ order or direction, and direct respondents, their servants and constituents to continue to make available to petitioners all licenses, service, facilities, concessions, etc. as done hitherto, being done at present, not to take coercive or indirect step to make the user of the land futile or defeat the objects of the grant in favor of petitioners. This is a prayer which is now seized off by the Honorable Supreme Court, and in that they gave this interim order at the instance of learned Advocate General making a submission. Then, my lord, this is third attempt.
Status quo is regarding land, subject matter is regarding land. Status quo does not permit them to carry on illegal activity. So status quo has nothing to do with this. It's a case of clear misleading. No, that is a prayer. What has been given subject matter is land. In fact, your lordship may kindly see in the earlier round of
status quo order, my lord, is at page 276 in volume 1 only, first volume.
301, page 301.
The direction of this honorable court was the land should be returned back to us. Our prayer before the court is, please continue the situation as it is.
The issue before the single judge was, my lords, which went to Supreme Court, is renewal of license. So the question before the court was renewal of license of the land, not of the racing. or of betting. It was never dealt, Supreme Court never dealt with, or the High Court never dealt with lacing rights or tough cup. Your Lordship may kindly turn to page 301.
Honorable Supreme
No,
Court.
page 301, just one
grants-
submission.
sorry, yeah, go ahead.
Page 301, in the year 2017, license was cancelled on identical. This court did not interfere. This court said constitute a monitoring committee. So therefore, to say that I'll make use of Supreme Court order with regard to land, so that I'll do what I want here, even if cannot be taken into such a logical condition. If at all, Maharaj, if that is the interpretation, you have to file contempt before the Supreme Court.
My lord, these are all cogs in the wheel. Lord, a conduct of a person, an authority has to be judged in the background of what has led up to this. Now the government tells us, you vacate and go withdraw your matter in Supreme Court. Till then, we will see how you raise. Several representations were given. Government, my lord, set up, identified two pieces of land. One is in place called Kunigal. horses, 8 horses like that. They're all thoroughbred horses. And each race has a stake, not just a price. There's a award given to the winner, is given to the owner of the horse, given to the trainer, it's given to the jockey. That is their livelihood. They are in this profession. So every time their horse wins, the owner gets money, trainer gets money, jockey gets money. All of them will not survive on this activity. 25,000 people, my lord, or 20,000 and not people depend on this industry in Bangalore itself directly. Now, my lord, what happens is they interdict all these things. And they, after the raid, they continue to give us license. That's why, my lord, your lordship's question, my lord, was, what was the last license that was granted? Was 7th of March 2024. They gave licenses for off-course meeting. They gave license for Bombay, Delhi off-course, and Bangalore on-course meeting. No problem at all. After the raid. Now, in the raid, my lord, what happens is, they go and say how much cash is there. And they count the cash. The 27 bookmakers, you know, they are bound to file return. They will file return. The law requires them, GST requires them to maintain accounts. 27 bookmakers whom we have licensed. Yes, who are operating in a designated area inside the premises. All of them, they apply to the club. The club, yes. No, the section 4, my lord, authorizes us. And when they give us the there's a format of an application, they give us the application, promptly it goes to the Commissioner of Police. Commissioner of Police and to his department gives us a police clearance certificate, income tax clearance certificate, Aadhaar card, everything details we take. Based on that, you give them a license. In the license, you put all conditions to say you have to maintain accounts, you have to file proper returns to GST authorities, you are liable to pay the GST tax. And we only collect whatever license fee we collect from him. That's all we collect, nothing more. We have nothing to do with their activity. My learned friend seems to think that we have to supervise them. There's no such requirement. There's no such provision. There's no, at no point of time, my lord, did they ever, not after all, if the police commissioner is sitting in my board and this is information, police department works on information. If they have information that something is happening there, he would have raised it in the board to say, look here, these bookies are doing something illegal. So what system do we have? Shall we put plain clothes mufti man? Shall we ask the GST department to pay somebody? My lord, in the liquor business, your lordship might know, under the Excise Act, excise department can place an inspector in the premises as and when the liquor is manufactured. It's not just physical control is there. Like that, they can do anything. They don't do any of those things. They say cash is found. Not in a business where all business is cash. If they found cash of 3 crores, and this great auditor, my lord, we have to give him some certificate for this forecast that he has done. How many people visited the race course in the last 10 years? And on those days, what was the collection? And what happened during COVID? What is the effect of COVID? All this he takes, assumes so many things, puts all these figures and says, I estimate this. And interestingly, my lord, your lordship, Justice Arvind Kumar will know, my lord, that the income tax department, how it works. If they get some information, they will work into the details. They look at the file. What has he filed before? What are his bank accounts? Thereafter, my lord, they will make an assessment. Last year, his return was 1 crore. This year, we found 50 lakh cash. Why is it that this is there? Did he have cash last year? This is the investigation that has to be done by the department. GST department has not done anything. If really, my lord, 200 crores is this a purported loss, whatever it is, GST department, my lord, would not, my lord, your lordship might know, supposing some cash is seized from somebody, my lord, by the police, first thing they'll do is they will intimate the income tax department. So much cash is seized. Income tax department will come, take custody of it, and thereafter they will do investigation. Nothing like that has happened in this case. That's why, my lord, our submission before the learned single judge was that this whole thing is something which is cooked up against us. The learned judge addressed himself to two questions. The first question was, after granting license for so many years, and after the raid on 12/1/24, you granted license for 3 more months for on-course and off-course. You didn't put any other mechanism in place. You had all the right to do everything. You did not even write one letter to the club to say, look here, such a raid has taken place. Please give an explanation as to what we can do about it. Who is responsible for this? Nothing, no inquiry whatsoever is done. They give us the license. Then, my lord, we give representation after giving, my lord, the annual fixture, my lord, how this works is, all India races are fixed throughout the year. Because, my lord, every city has got a different, my lord, Ooty, for example, it runs only in summer. Winter, there's no racing. Bombay, there's a winter racing. Bangalore, there's a winter racing. So these dates are all synchronized. So whenever race is run in Bombay, we have an off-course betting here. Say there's a live television is there, races are seen. There are totalizator, which is a system run by the club. They have given us a certificate to say our totalizator is run completely, transparently, electronically. Everybody who wants to bet can go and bet. Tax is deducted automatically, no problem. Bookies are a problem. So the learned judge, my lord, examined and found only reason given, without any report being called for, only, sorry.
2 minutes.
Just may give us 10-15 minutes tomorrow.
Meeting. 10:30. 10:30 in the morning.
10 o'clock.
10 o'clock. Morning first session, otherwise. That's by afternoon, my lord. But morning, my lord, because
Race is at 1:30 is the race. If the race is
please.
yes. I'll take less. I will not take.
Please, ma'am. Please. Please.
No, I'll try to be not as brief as possible. So, not we see this background, and the lordships have already noted the lot the 3 licenses granted up to March. Then our applications to now, and after the application, we give 2 representations to what John the Chief and the additional chief. One of my submissions was, you are granting or refusing the license. You have to take everything into consideration. One is, if this is illegality, you have to consider that also. I'm not saying no. Secondly, who did it? Thirdly, what is the impact of your refusing license? Lord, kindly just permit me to show a few lines in that, my lord. Page 382 in volume 2, my lord. I'll not read it, my lord, but just take your lordships through, my lord. volume 2, page 382. So representation to the Honorable Chief Minister. This is in the month of April, after waiting, my lord, for nearly 20 days. Our applications, my lord, were filed on 21st of March 24. 8th April, we write to the Honorable Chief Minister. Background we gave, not 160 years of racing. What is the racing activity? How much is the license fee? Employment, financial earnings, the GST that the government is earning from totalizator and betting in the, then animal welfare, how many animals are there? How many stable workers are there? And how do they survive? Lord, if the trainer doesn't get any income, he will not pay his employees. And these are all, my lord, not, what shall I say, my lord, in the organized sector. Then financial status. Then we also touched this question about relocation of race course, because that was the bugbear. They said, you go away. He said, we're willing to go, but please look at all these things. Then not one more representation, and that's all, not 450. Oh, I'm sorry, I didn't realize. I thought your lordships are continuing to sit, but your lordship said we'll come back at 6. I'm sorry, then I'll stop. I thought your lordships are deciding to continue, but if your lordships are coming back, we'll wait now. No difficulty. Please. Your lordships may guillotine me at any time. I will stop at the moment. Page 450. That is the second representation we give 1 month later. And in this, my lord, we say, till now we are applying for off-course racing. Now Bangalore racing season is starting. At page 451, first line on top, we wish to draw your attention to the fact that the Bangalore summer meeting, which is premier racing season in the country, in which horses from all over India will be participating, scheduled to commence on 18/5 for the purpose of the rural horse professionals. We give all the details. And again, my lord, in action, so we have no choice but to move the Honorable Court. We file a writ petition, my lord, and trouble the Honorable Vacation Bench. And the Honorable Vacation Bench, my lord, passed an interim notice order on 21st of May, when the learned vacation judge, my lord, directed the government to say, what do you want to say? And on 23rd, my lord, he said, this race is starting, why don't you give the license? Let them run, and then you can consider. They said, no, we would like to hear them. My lord, in the order, I'll just conclude, my lord, I'm not reading, my lord. In the order, my lord, the learned Advocate General drew your lordship kind attention to some portions of it. But I would only like to say, my lord, the approach of the learned judge, my lord, I would respectfully commend it for acceptance, my lord. The approach has been, you have power. Repeatedly, they are saying Section 8, no court shall interfere. My lord, it's too late in the day to say that a writ court should not interfere with any order because of a statute. That does not, my lord, lie at all today. The writ court, my lord, has every authority and power to look into unreasonableness. The only reason they give is this raid and this so-called seizure of cash from somebody. No proceedings instituted. And another thing, my lord, is in the charge sheet, the club is not made a party, my lord. All breach of trust under it. The company has to be made a party. Only then officer can be made a party. They have not made any allegation against the club. So the club is not even a party in the charge sheet. They're trying to faintly say in the objections, oh, chairman representing the club. Lord, there's a world of difference. If a corporate body is an accused person, it has a choice to designate A or B or C to represent it in criminal proceeding. And of course, A or B or C who is designated cannot be put to jail. Only fine can be imposed. That's not a well-settled proposition. And now before the criminal court, when it's challenged, the learned Advocate General, my lord, gives an undertaking, will not precipitate. Now, my lord, your lordship knows, my lord, vacation court is hearing the matter. If the respondent side come and say, okay, he is pressing for interim relief, You would say you don't precipitate. Then the judge will say submission noted, therefore adjourned. Then, my lord, please. So I only want to say, my lord, that the order is well structured, well considered, and the learned judge has considered that important point, in what cases the court can grant such relief. The learned advocate general vehemently opposed it. That is considered with authority. And the learned judge says that in the facts of this case, because such a large number of people are there, there's very unreasonableness. You don't look at anything. Therefore, my lord, there's interference with this order. And my lord, ultimately, public interest, your lordship is not, government is big, I understand. But there are large number of small people that are involved. I have no personal benefit. The club does not benefit anything. So if racing goes on, my lord, nothing is going to happen in this. And that's all. Yeah.
Back at 6 or 8. I represent the Racehorse Owners Association. Yes. 6 o'clock, I would, Lord, this night watchman is a little difficult. My lords, I will confine my, very well. Lords, I will
We should give a few minutes to the learned advocate general also before that. We'll do that. We should give a few minutes for reply to the learned advocate general before 6:30. We will do that. Of course, we'd like to be enlightened.
Can I make a mention?